discussing today will begin to commence a new direction in the total perception, total perspective, and the package of our judicial system in Nigeria by God's grace. Let me quickly just recognize the number of our distinguished guests here. We have representing the Ogun State Minister for Justice and the Attorney General, Mr. A.A. Adewale. Please just wait to that's all the way from Abeokuta, Amosu. I think we should also accommodate Siakia too, please. We also have representing the Minister of Information, Alhaji, our very own, very popular Alhaji Lai Mohammed, the Director of the National Orientation Agency, Lagos State, Mr. Wahid Ishola. Please don't stand next to you. We have representing don't mind me. Once in a while that I get to hold the mic, I realize that the most important duty I do here is to mention names as appropriate. So if I'm miming like deaf actor, maybe I'm trying to rehearse names, especially when you have someone scrawled a name like that of a hen here, and I still can't get it. Anyway, we'll proceed. I can tell you that we have the chairman of this event on ground already. We have a special guest on ground already. Once the event commences formally, as I said, comments formally, the opposite of formal is informal. So what I'm doing is still informal. At least we are engaging ourselves, but once the events commence formally, we'll introduce them. And we know the kind of role he played during that time. And of course, we can start differentiating the ICPC then and the ICPC now. Please, a big round of applause for And with us here is the Chief Justice of Nigeria. Well, I'm very sure those who have seen his picture want to identify him here. But I can tell you, the Chief Justice of Nigeria is just here. Well, I'm very sure those who have seen his picture want to identify him here. But I can tell you, the Chief Justice of Nigeria is clearly represented by no further lady mind, the Colossus of the Supreme Court of the Republic of Nigeria, and somebody who is in the legal world. We don't say women, we say men. I would say the son of the soil in the human flesh. Distinguished Honorable Justice Kudirat Utomori Kekere. These are the very distinguished female species of humanity that has brought pride, and pride and beauty to being a woman. Justice does not need to wait for 35% affirmation to be a justice of the Supreme Court. This justice is not a justice by allocation. This justice is a justice by hard work and competence. All right, and also with us, it's the Chief Law Officer of Nigeria, of the Nigerian Federation. Of course, we all know the Chief Law Officer of the Nigerian Federation was a guest of the Nigerian Senate, I think 2 days ago. Still a proud how do I call it now, in his effort to extricate himself from an allegation of being biased in the case of perjury against the Nigerian Senate. So all of we have not seen him, we have heard about him, and he is here with us. Please.
Well, we have a representative of the Attorney General of the Federation and Minister for Justice, and it's represented by a woman also, Mrs. Ngwabi, the Senior Special Advisor to the President on Access to Justice, and we're here for Access to Justice. This is one of the president.
Now we can all assume that the women are taking over. So perhaps we have to start to compute that 95% affirmation. But the fact is we have that work already filling the space. You are welcome. One of our guest speakers is a very distinguished legal man. Perhaps the very best person to confuse him with his legal title. What we always know in Nigeria, in our illiteracy, legal illiteracy, is the title of SAN, Senior Advocate of Nigeria. All of a sudden we started hearing breast cancer and all that. Something is wrong somewhere. Now this man has the double bullet for him. He combines this and that. Please help me welcome Professor Fidelis Odita, very distinguished.
Professor Fidelis Odita is the King's Counsel of England and as well Senior Advocate of Nigeria. That's why he said he has a double bullet to his advice to his government.
And he only has one head, not two heads. The professor, King's Counsel and the Senior Advocate of Nigeria. Round of applause for this.
Next is our own Professor Bolaji Owasanwoye, formerly I would say of the Institute of Legal Studies, and today is the Chairman on Anti-Corruption Campaign of the Federal Republic of Nigeria, the Secretary of the Anti-Corruption Campaign of the Federal Government of Nigeria. We have been represented here today by no other person by my own lecturer, Dr. Abiola Swami of the Faculty of Law, University of Lagos. A round of applause.
And Including that, only has just shown to us that corruption is everywhere. I have been introducing the names and the details. Because this one is a selector, he has to introduce and give details.
I'm going back to my PhD.
Alright, we would excuse that. Yeah. Oh, yeah. This is one big name, very big name. I have been following personally, especially some of the cases they handled on behalf of Lagos State, the recent past. And I'm very sure you are very familiar to this name and with this name, Mr. Fola Worry.
Former Solicitor General of Lagos State.
Perhaps you don't know the report. Perhaps you don't understand the person of Fola Otowori. One, from that worry, I think he's a warrior. And the truth of the matter is, if you had followed what this gentleman pursued when he was the Solicitor General, he was the first Solicitor General to make that office popular. What we've always known, I think, the Minister of Justice and all that. Then we had this man come and became Solicitor General, and we didn't hear anything about the Minister, the Commissioner for Justice or Attorney General at that time. Then now, if we are enjoying the luxury of security in Lagos, please, you will have to give a big round of applause in acknowledging that to this gentleman who is the Secretary of the Lagos State Security Trust Board. Do you want to appreciate him on that?
Last but not least is Mr. Shegun Adeniki, who is not here with us right now. Mr. Shegun Adeniki is developing a Nigerian crisis coordination, in which right now he is being at the airport in Abuja since 7 a.m. The flight has been scheduled several times. So if we are lucky, we may have him join us before the end of this program. Let us keep on respecting him. Please, that purpose many resources.
Nigeria is a beautiful country, especially the aviation sector. You get made to pick your flight for 5 minutes, you are fine. But if the airline decides to move your flight to 24 or the second day, there's no worry, they send you a text, and sometimes they tell you, why didn't you even reply that text? Or to an uncommon number. So it's the beauty of Nigeria, I would say. As we have constituted our panel fully, it is just ceremonial that we acknowledge this gathering of big, massive, mighty brains. A round of applause for this very distinguished panel. On this note, let me quickly invite the distinguished convener of the United Action for Change, the man who has invited all of us here for his opening address. A big round of applause for Dr. Luis
The chairman of today's occasion, my Lord Honorable Justice Emmanuel Ayola, retired Justice of the Supreme Court and former chairman of the ICPC, my Lord, the Chief Justice of Nigeria, ably represented by my Lord Honorable Justice Kula Kekereokun, the Attorney General of the Federation and Minister for Justice, Mr. Baka Malami SAN, ably represented by the Senior Special Advisor to the President on Access to Justice, Mrs. Owagu, our distinguished speakers, starting from my Oga, Professor Fidelis Odita, Queen's Counsel, Senior Advocate of Nigeria, and Professor Bolaji Owasoye, ably represented by my colleague Dr. Abiola Soni of the Faculty of Law, University of Lagos. My brother, former Solicitor General, and one time also Honorable Commissioner for Land in Lagos State, as well as the pioneer, also a pioneer Executive Secretary of Lagos State Security Trust Fund, Mr. Fola Atowori. And truly he's always been worried about everything about Nigeria. He's written so many books to express his grief and so many things. And I'm sure some of us are conversant with his works in this respect. Mr. Fadawano is here awaited. Mr. Chegbadini, I'm aware he has run into turbulence of flight. So we're hoping and praying that they arrive safely. Senior advocacy are present, particularly my brother, Mr. Bolaji Ayolide, Mr. Lawan Pedro, Mr. Chino Chufola, Chairman and other executive members of various branches of the Nigerian Bar Association in Lagos. My brother, the director, representing the Attorney General of Ogun State, you are welcome. And other distinguished ladies and gentlemen, too numerous to mention, and of course, men and gentlemen of the first estate of the realm, you are all duly acknowledged. It is my pleasure to welcome all to this maiden edition of the public discourse of the United Action for Change. It is interesting to gather here today to seek to provide solution to one of the major problems bedeviling our society, which is the need for access to quality justice. As we see, we say quality justice, not justice, ordinary justice. There are so many types of justice, but here we are talking about access to quality justice in our dear nation. The United Action for Change, by way of introduction, is a non-partisan, non-governmental, and not-for-profit organization committed to the actualization of the positive change which an average Nigerian gets for on a daily basis. In order to give our contribution to the recovery of our ailing society, we are volunteer all that it takes by embarking on several programs towards the realization of the change mantra. For example, this group organizes regularly several roundtables, in fact monthly roundtables to deal and discuss the various parts of the challenging areas in our nation. For example, at the point in time we are discussing the issue of managing Lagos State, we are discussing the issue of power, the issue of oil and gas, the issue of corruption, and so many other ones, which is a monthly routine for this group. Also, as part of our group, we held the first ever town hall meeting with the Vice President of the Federal Republic of Nigeria, Professor Yemi Oshiba, in our guest at the town hall meeting. And today, we will equally be presenting the report of the roundtable on the reconstruction of the judiciary to the Attorney General and my Lord, the Honorable Chief Justice of Nigeria, will be represented. Today's effort became more imperative due to two basic developments in recent times, and I'm sure this certainly form part of the basis for convening today's discourse. And the story of the night goes thus. One, a judge gave a judgment in a particular state in which the state government was involved, and judges somehow went against the state government. One, a judge, some few months thereafter, the said judge fell ill and had to be operated upon abroad. He immediately found out of the source, and the fire ended up on the table of the chief executive of that state. Of course, you can imagine what could have happened. Somehow along the line, and over senior subordinates, suddenly, through the attention of the chief executive, but that was the judge that gave that judgment that time. What now happened to this particular file? Of course, the governor was reported to have been beautifully thrown the judge trial away as an enemy of the state. The second thing that which postulates the need for independence of the judiciary, a component of which is adequate funding and financial autonomy, was the equally the case of another judge who ruled against the judge and had to the state and had to face the persecution thereafter. It is based on the above background that it becomes quite imperative to seek independence for the judiciary, which is a substratum of the rule of law. An incapacitated judiciary has never guaranteed confidence of the public in the judicial system and can never be a guarantee to political economic development. And certainly no investor will be confident enough to put in any investment in a society where the rule of law is threatened. To that extent, for example, I'm sure that most lawyers are aware of two decisions of our court in respect of the budgetary independence or the funding independence of the judiciary in this the Judson case as well as the Abakoba case. And of course, we all are aware of the provision of Section 162 subsection 9 of the Constitution of the Federal Republic of Nigeria on the funding of the judiciary. But what is the situation today? Virtually all the states, they still have to go cabinet to the chief executive of the state to get the necessary approval. I had the opportunity of having a discussion with one of our chief justice recently who told me that the last time that they ever got impressed on running costs was in February in our state. And of course, you know the implication of that on the administration of justice in our dear nation. Why the independence of the judiciary is important, it is equally imperative to examine the state of the judiciary itself, in terms of not only the welfare, but in terms of the delivery. We are of the opinion that it is necessary to x-ray other stumbling blocks to access to quality justice, which might be in terms of corruption, as well as attitude of justice, as well as other administrative staff. These are part of the reason why this public lecture is organized to ensure that the adult tempo of justice is never desecrated in the interest of all of us. Distinguished ladies and gentlemen, these are part of the responsibility that confidence of God has cast on all of us as a people. These are part of the duties humanity requires of us as part of this collective demand. We hope to continue to discharge same without fear or favor. It is on this note, therefore, that I formally welcome you to this symposium on access to quality justice. I thank you very much. God bless you.
Now the tone is properly set for further discussions from the distinguished convener of United Action for Change, Dr. Liz Adeyemi. Round of applause for him. And don't forget to this platform, this event is put together by UAC without any funding from anywhere. It's organically funded by UAC, and then we have to give UAC a big round of applause for it. So now we finally get into the mood, as the social media people would say. But let me quickly announce that you can also engage on social media during the conversation on Twitter at #UAC Access to Justice, and Twitter again OUACNG. Then our live stream is www.uacng.org. So you can those who cannot be here, please tell them to join us on Twitter. We will now formally invite the chairman for this very distinguished event, Justice Emmanuel Ayola, retired. Former chairman, ICPC. I can't tell you this.
I can hear you very well. The question is very loud. All protocols duly observed. It is always a pleasure for me to be in Lagos because it has its special attraction, has special people. Lagos has quality people. Let me flatter myself. That's why I was invited as a quality person. All protocols have been duly observed. When I was invited to be the chairman of this occasion, it was because Dr. Banire is Dr. Banire that I accepted. Because after some time, I think when you have retired as a judge, you try to retire completely so that you can sit under a tree and dream dreams and see visions. It is a pleasure indeed to be in the presence of such a gathering, this wonderful city and this wonderful state. If I were to dispense quality justice, what I should really do, following what I have before me, is either to ask the next speaker, Professor Odita, to come forward, because according to the program, Professor Odita should be speaking by this time. But I have a letter policy suggested to me, so that we keep within time. Can everybody please turn the clock back when I'm supposed to be making my opening remarks? So we believe that I am speaking 10 minutes past 11. Professor Peter speaking later at 10:15 to 12. How long has been that? First, let me say how wonderful it is that Dr. Banire talked about this idea of divine action for change. Nigeria is due for change. Nigeria is due for change for the better. And the time is right when every citizen of Nigeria must see himself as a change instrument. We who have lived in the past and left to live also in the present have experienced wonderful change in Nigeria. We've seen change for the better, and I don't want to say we are seeing, we will not see change for the worse in Jesus' name. But I can assure you that those of us who lived, not centuries ago, but decades ago, are worried about the trend in Nigeria. We are worried about seeing young people in Nigeria whose only aspiration is for wealth. We are worried about the young generation who have no aspiration whatsoever other than to ask for the good things of life without working for the good things of life. We have experienced even old people who don't think about change because they themselves feel what you see the change. What can go on endlessly? But I'll revert to the topic of this glorious lecture, access to quality justice in Nigeria. And I begin to wonder, what really is quality justice? Because let me step out so that this eminent learning way, vibrant learning way, will tell us what justice really is. I will challenge you by saying that justice is justice. Justice should not need qualification. Anything that qualifies justice is an exaggeration. Justice must be justice. But since they are going to challenge the spaces which I do, let me join those who will speak after me by proposing that Nigeria will have justice. Nigeria will have justice that is legal justice. Nigeria will have justice when we have quality teachers of law who will produce quality students. Quality students who will be quality legal practitioners. Quality legal practitioners who will be legal practitioners practicing before quality judges. When we get to the stage of quality judges, then those judges will be admitted to quality justice to quality people. So Nigeria must, the average Nigerian must aspire to become a quality person in himself, who will seek quality justice before a quality judge. A quality judge who will have a quality legal practitioner practicing before him. A quality legal practitioner who would have been taught, who would have been a quality student. Quality student who would have been taught by quality professors like Professor Peter. It is a pleasure that we have in our midst today quality people who will speak about quality justice. Let me say, before I exhaust my time, which is only 5 minutes from this moment, that I believe that we started Nigeria when Nigeria started with quality justice. I believe that Nigeria of the past had people who were not even learning the law. Dispensing justice. We must count back to the past. We must not forget our origin. It is because Nigerians and Nigeria are beginning to forget their origin that we need to gather this moment, this morning, to talk about quality justice. It is a pleasure to have the discussants on the podium. Professor Odija is a first class guest. We have first class student, University of Lagos. University of Lagos.
Good job.
They say that's not that. University of so we accept that. We have first class university, first class law school. Then when people say education in Nigeria has become very poor, education is in Nigeria, it's quality education. Think about Professor Odija, who went to England, went to Oxford University, and became a professor, not only a professor, before that became a quality student, and from there he became a quality legal practitioner in England. And when people want to denigrate Nigerian education, I say, no, cannot be correct. Because I know one distinguished quality person who has the courage to be a professor in a university in which I was just a student. It is a pleasure to welcome Professor Odija to this program. We are all looking forward to the questions. Then the other discussion, Bolaji Owasoye, ably represented by Dr. Soli. Professor Bolaji Owase has become a quality anti-corruption fighter. Not only a fighter, but anti-corruption warrior. We wish him abundant success in this new assignment. I was going to say Professor Fola at the war until I remember that he become a trustee of security people. And I wish him much success. He's doing it. But finally, I deliberately reserve this moment to welcome the representative of the Chief Justice of Nigeria. He's the embodiment. She is the embodiment of quality justice. But I must plead, fortunately, lawyers are not, citizens are not very, they don't practice that great law. Because if it were the old days, the days of our useful primaries, we should all be calling justice in quality justice. I know that justice should will reach bigger profession and judiciary. Also, the Attorney General and Minister of Justice is asking for able representative. Well, I was once the guy, but I'm more familiar with the president. The special assistant to the president on justice sector reform. We need to talk so that we can have quality reform in the justice sector. Finally, it is my pleasure to welcome Dr. Soli, who is represented Professor Owase. Now, 5 minutes exceeded by 1 minute. That's the quality of justice.
That would only come from a very distinguished quality mind. A big round of applause was given. Now, by that conduct, you know it's a quality conduct. That's now formally inaugurated panel and set debates and discussion. But before we proceed, I want to seek the permission of the chairman to review the program as prepared, so that we can have, by the way, I quickly announce this. Since our chairman here has christened the Justice Kekere here as quality justice, we may as well adapt as in addressing Justice Kekere, we would say Justice Kudirat Kekere, aka quality justice. And on that note, we want to realign the program so that we will have the Chief Justice of Nigeria present, or rather, who was a privilege speech, and that will be the person of the representative of the CJN, Justice Kudirat Kekere, aka
My Lord, the Honorable Justice Emmanuel Ayola, the retired Justice of the Supreme Court, and retired head of the ICBC, I'm very, very humbled by all the words, the kind words that have said about me. And I'm so happy that we still have my Lord around us, because he has been a great inspiration to those of us on the bench. And we all aspire to reach the heights that he reached in his erudition. The Honorable Attorney General, ably represented by Mrs. Ibekaku Uwaku. The next speaker, Professor Fidelis Ojita, Senior Advocate of Nigeria. The discussants, the representative of Professor Bolaji Obasanjo, the Chairman of the Presidential Advisory Committee Against Corruption, Dr. Abiola Sani, Mr. Fola Athawari, a very, very well-known figure in Lagos State, who, in whatever position he has occupied, has always excelled, and we look forward to continued excellence from you. The convener, Dr. Louise Marira, Senior Advocate of Nigeria, Senior Advocate, members of the bar, distinguished ladies and gentlemen. It gives me great pleasure to be asked to say a few words on the occasion of this public lecture with the theme Access to Justice in Nigeria. The timing of this public lecture is auspicious, as the Nigerian judiciary in recent times has been under a very bright spotlight, which has inevitably exposed some of its flaws and shortcomings. I must commend the United Action for Change and the convener, Dr. Louise Marira, Senior Advocate of Nigeria, for having the foresight to organize this event. It is encouraging to see efforts of this kind aimed at discussing appropriate solutions to the myriad of challenges facing justice delivery in our country. We are all an effective administration of justice, and each of us has a role to play in achieving that end. The topic of today's lecture, according to the letter of invitation that I received, is the dangers of a compromised and incompetent judiciary. I say this because this is the platform on which the present government was elected. We all say we want change, but when signs of change are coming, we don't seem to be comfortable with it. Many of us still want business as usual. So let's ask ourselves, is that change? Now, one of the ways to embrace change, in my view, is to change the narrative. I believe that while it is very positive to look for ways of improving access to justice, we must stop denigrating our judiciary. I say this because, as we all know, the judiciary is the last hope of the common man. And when at every available opportunity, all we emphasize are the negative aspects of our judicial system, it doesn't do any good for our country. We know that there are problems, we will face those problems. But in this age of internet technology or communication technology, imagine anybody, a foreigner wants to know about the Nigerian judiciary, they go onto the internet, most of the time, what you find are all the things that are wrong. We are on a journey, there's a process, efforts are being made to improve, but I think it's also important to celebrate the things that are good about our judiciary. Now, the Vice President, Professor Yemi Osinbajo, Senior Advocate of Nigeria, at a recent event in Abuja called Words of Gold. It was an event organized by the Law Pavilion in Abuja 2 days ago to celebrate past and present justices of the Supreme Court. And he noted that Nigeria, in spite of all our shortcomings, has one of the most vibrant Supreme Courts in the world. Such support from the nation's #2 citizen, who is also a senior advocate of Nigeria, is a positive step in changing the negative narrative about our judiciary. It must be recognized that no matter how transparent the way of appointing judges is, no matter how qualitative the members of the bench are, to use the quality justice appendage, or how competent they are, if we persist in arguing and deciding cases on the pages of newspapers, a judge who decides a case in accordance with the facts and the law may still be perceived as having been compromised because his finding is not in accord with public sentiment. Legal practitioners must be brave enough to give their clients honest advice about the prospects of their cases rather than engaging in all manner of delay tactics to stop proceedings to delay the inevitable. This type of conduct, in my view, amounts to corrupt practice and is certainly responsible for some of the delays experienced in the dispensation of justice. The practice of giving financial inducement to court staff to carry out their official duties is also a form of corruption. Court staff are bound by the code of conduct for court employees. If they breach any of its rules, it is viewed as misconduct and they are liable to disciplinary action. Judicial officers, apart from swearing to a judicial oath on assumption of office, are bound by the code of conduct for judicial officers. Infractions of the code of conduct for judicial officers could result in disciplinary action by the National Judicial Council once the proper procedure for making a complaint is followed. The point being made here is that again there are a lot of negative comments about a lot of judges and justices. You read a lot of things in the newspapers. But what is important is that there are avenues for addressing these issues. And the National Judicial Council has been very much up and doing in disciplining judicial officers. So it's important that rather than just casting aspersions, we follow the correct procedure. Part of the change called for is for anyone with a genuine complaint against any member of the judiciary to make a report to the appropriate disciplinary body supported with proof. It is unfair to the person against whom an allegation is made and to the institution as a whole to constantly have wild and unsubstantiated allegations in the press and on social media against judges who cannot defend themselves. Many of these allegations, which are given the widest publicity, have the effect of seriously damaging the image of the judiciary and eroding public confidence. Once the public loses confidence in the judiciary, the society will descend into chaos and anarchy. Where there is a lack of confidence in the judiciary, it affects the nation's ability to attract foreign direct investment, which the country sorely needs at this time. It has an adverse effect on every aspect of our existence. As individual stakeholders, we must do our bit to improve the access to justice in Nigeria. As judges, we must exercise our judicial powers in a fair, honest, transparent, efficient, and effective manner without fear of favor, affection, or ill will. As legal practitioners, we must uphold the rules of professional ethics which stand us apart from other professions. As law enforcement agencies, we must carry out our duties professionally and in accordance with international best practices. We must not show bias and must have respect for the rule of law. As court staff, we must carry out our duties diligently and efficiently without expecting any form of inducement in cash or kind. I would also appeal to our senior members of the bar to actualize their role as leaders of the bar. You must set examples for the younger members of the bar and keep them in check where they fail to uphold or maintain the ethics of the profession. I believe that when we were first called to the bar, whenever you go to court, if there's a senior advocate in court of the ilk of the late Rotimi Williams, Kiri Ajayi, Kehinde Shofola, and the rest, when you enter the courtroom and you see them, the first thing you do is to look at yourself and make sure you are under this first and foremost. Secondly, you cannot be seen in court with a magazine or a newspaper when you are in court for a case. you'll be called to order. Nowadays, I feel that we don't have this leadership anymore. I find that the senior members of the bar, they just come to court, they do their cases and they leave. Sometimes even the juniors that accompany them are not proper interested. And a lot of the examples they set is what is being followed by those coming behind. So I would like us to please have another look at that aspect of our profession. Now, at the 8th Honorable Justice J.I.C. Taylor Memorial Lecture on restoring confidence in the judiciary, the role of the bar bench, delivered on the 30th of November 2011 by Honorable Justice M.M. Akobi, CFR, former President of the Court of Appeal, also former Chairman of the ICPC. The learned jurist quoted the Lord Chief Justice and President of the Supreme Court of Kenya, Dr. Willie Matunda, as follows, and I quote, "The existence of court alone provides no guarantee of justice. Rather, it is the value and quality of the people who lead it." Note that word, quality. The aspiration and design of the Constitution that creates it, and the vigilance and civic consciousness of the people who continually demand better. Unquote. No doubt, this is why we are gathered here today. It is hoped that the issues and suggestions generated by this lecture will encourage us all to do everything in our power, collectively and individually, to restore the integrity of our judicial system, the ethics of our legal profession, and respect for the rule of law. It is also hoped that the deliberations will profile practical ideas on how to improve access to justice in Nigeria and rebuild public confidence in the judiciary. I wish us all very fruitful discussions. Thank you for your kind attention.
I can't hear you, please. Please. Now, the summary there is that the CJN has read the Riot's Act. See, and for that, let's have a very loud round of applause. From our own dear Justice Secretary, aka you. We are going to make this one stick. All right, now we go into the main body of the session.
Represented by Mrs. Juliet Baru, shall present the Attorney General's short speech.
Representative of the Minister of Justice.
And Lord, the Chief Justice of Nigeria, ably represented by Justice Ekereku, Justice Ayola, retired Justice of the Supreme Court, Professor Duka, SAN, Mr. Folo Afowore, Dr. Badire Muse Badire, the convener of this program, and the National Legal Advisor, ABC, Professor Rosana, ably represented by Dr. Sonny, distinguished guests. I'm here to represent the Attorney General of the Federation and Minister of Justice, Mr. Abubakar Malami, SEN, and I read his speech. I am delighted to be in the midst of legal luminaries today. I am quite impressed with the organizers' foresight in convening this forum, and commend them for taking steps to articulate the roadmap towards the improvement of access to justice for all Nigerians. In this regard, I single out my learned colleague, Dr. Muse Badire, SAN, and the National Legal Advisor, ABC, the convener of this unique event, for recognition. You will already be aware that all hands are on deck at the federal level to articulate a justice sector reform in Nigeria. The articulation of this justice sector reform plan is based on our assessment of the current challenges facing the justice in Nigeria over the years has been bedeviled with a series of challenges, such as inadequate human resource, lack of funding, poor internal management, poor accountability mechanisms, and lack of coordination across the justice sector institutions and other acts of government. These challenges have made access to justice a clear path to achieve. We recognize that access to justice is critical, and taking into cognizance the words of Right Honorable Beverly Macklin, the Chief Justice of Canada, that the most advanced justice system in the world is a failure if it does not provide justice to the people it is meant to serve. As such, we consider access to quality justice as the ability of people to seek and obtain a standard remedy through formal or informal institutions of justice for grievances in compliance with human rights standards. Hence, access to justice goes beyond improving a citizen's access to court or guaranteeing legal representation. It extends the ability of formal or traditional justice institutions, both at the local, state, and federal levels, to ensure that laws, rules of engagement, and respect for human rights are upheld. It calls for a radical review of the way the Nigerian justice system is currently structured. The quality of timeliness of justice delivered is what makes access to justice an effective instrument for the protection of rights of all citizens. In view of the foregoing, the Federal Ministry of Justice has set up a justice sector reform team, led by a special advisor to the President on justice sector reform. The justice sector reform plan, currently under review, sets out a vision that seeks to provide timely and accessible justice to all Nigerians in an efficient manner, regardless of their ethnic group, gender, marital status, age, economic status, disability, religion, belief, culture, language, or any other attributes. Our objective is to restore public confidence in the administration of justice in Nigeria. The objectives of this justice sector reform include: 1. To strengthen our ability to undertake legal drafting and law review process. 2. To strengthen prosecution, adjudication, enforcement, and asset recovery mandates. 3. To strengthen public engagement and accountability systems. 4. To support international cooperation and national coordination across justice institutions and with the judiciary as well as the legislature. The overall objective of the reform plan is to develop and implement a broad-based reform program for the justice sector in Nigeria. The reform plan will set up key priority areas and identify funding gaps for the sector. It will also highlight the strategy for engagement with the public and how the justice institutions will be assessed over the next couple of years. It sets out the steps towards the establishment of principles of efficiency, transparency, and accountability within the justice sector, as well as respect for the constitution and rule of law in Nigeria. So what do we expect to come out of this work when we start implementing the roadmap for justice sector reform? Our expectation is that we're going to see improved coordination of the justice sector, improved enforcement and prosecution of complex criminal cases and corruption cases, improved stolen asset recovery procedures, and increase in the amounts recovered from corrupt politicians, public officers, and corporate bodies, improved administration of the criminal justice system, improved relationship with the security sector, improved respect for human rights and rule of law in Nigeria and reduction in impunity, improved skills of law officers, improved interaction with businesses and improved investment environment, improved internal accountability measures and reduction in internal corruption across anti-corruption and justice sector institutions, improved working relationship between the executive, the legislature, and the judiciary, leading to improved handling of complex cases, improved relationship between the Federal Ministry of Justice and non-professional actors as well as professional bodies. This justice sector reform plan will intervene at different levels and will lead to an improved administration of justice in Nigeria. Consequently, the justice reform plan will mainstream coordination within the justice sector and with the judiciary, the legislature, the state, local government, and community level justice institutions, as well as the civil society groups. The ministry, we are also mindful of the need to be inclusive in our approach. As such, we will take cognizance of people with special needs, the vulnerable, children, women, and youth, particularly those who are disadvantaged by reason of single conflict or status in life. We will build on the previous efforts of the Ministry of Justice Reform Initiative through the Federal Justice Sector Reform Coordination Committee to support the implementation of the reform of the justice sector, not just at the federal level, but also at the state level. In order to support the implementation of this reform plan, we will seek for the approval of a budget that will ensure that the justice sector has a dedicated justice sector trust fund, just like the education trust fund, and through proactive engagement with international and national development partners. As part of the justice sector reform plan, we have also commenced a consultation session to introduce and review the National Anti-Corruption Strategy document. The National Anti-Corruption Strategy document is an anti-corruption instrument that for the first time seeks to address the menace of corruption in Nigeria in a more comprehensive way. The document is an instrument for national anti-corruption engagement to fight corruption. It brings together the bodies constituted and empowered with anti-corruption mandates into a cohesive institutional framework for a more coordinated and collaborative channel for the prevention of corruption and the enforcement of legal and policy measures against corruption. This national anti-corruption strategy will chart the pathway for the key agencies to harmonize their operations in order to function with a single strategic focus and purpose, while using specific specialized tools to make the control of corruption much more effective and successful. On this note, I welcome all of you to this program, and I wish you fruitful deliberations.
Very familiar with the reform strategies and it's ongoing to become activated in the judicial sector very soon. And this is Mubako is actually the special assistant to the president responsible for that reform. So it's actually rolling out a manifesto, for that for the sector of our office. It's a different purpose. All right, now, I was hoping that I was able to do a recap of the opinions the chairman, distinguished chairman, get all on this very quality person. So unfortunately, I also lack the capacity of the chairman to solve the situation. So I want to concede my next quality capacity. But it is my privilege to invite the professor, the Prince Counsel, senior advocate of Nigeria, and most importantly, the great advocate. Please, Professor,
thank you very much. I must begin craving the indulgence to stand on the existing protocol. In doing that, I'd like to thank our chairman, especially for his very kind words. I've had the privilege of meeting on many occasions. On the 20th of February 2004, communication of the empowerment from the Supreme Court, I had the privilege of being invited in Lagos by Professor Shivaji, who was then the Commissioner for Justice, Attorney General of Lagos, to speak on the topic of the role of tradition in developing countries. So it's a great honor for me to be invited today to speak on a topic which is not dissimilar, not very far from that topic. Also, on the 9th of December last year, I was invited by the Center for Sociological Studies and the Presidential Committee Anti-Corruption to speak on the role of the courts in the fight against corruption. So I've had some recent experience. The topic today is somewhat a contradiction in terms. For many people, to many observers, the problem in Nigeria is not access to justice. The problem in Nigeria is exit from justice. When you come into the Nigerian justice system, you'll be begging to get out. But you'll be held there, pinned down for many years, not going forward, not going sideways, almost motionless. So for me, I'd like to suggest a slight modification of the topic, exit from justice in Nigeria, rather than access to justice. But I suppose Dr. Moise, you must have something in mind in asking me to speak on access to quality justice in Nigeria. I think a useful starting point in a discussion such as this is to identify what the key determinants are of what you call quality access to justice. Because unless you know what should exist in a high quality justice system, you won't know whether in Nigeria we have that or not. So there must be some benchmark against which you have to judge access to justice in Nigeria. It seems to me that a useful starting point would be to identify some of these determinants, and without in any way implying that these are exhaustive, I would suggest the following. First of all, the existence of the rule of law. I know this has many applications. That thing called the rule of law, that all individuals are subject to the rule of law rather than the whims of men and women, must exist in all its forms, including the independence of the judiciary, the separation of powers, and so on. Those things must exist. Because as my lady Justice Kekere pointed out, Nigeria is in competition with every other country for investment. And the quality of our justice system determines the willingness of foreign investors to invest in our country. If people perceive our justice system to be inadequate, not to provide them timely remedy, not necessarily winning, they might not invest. And that's why we have seen, to some extent, the willingness to embrace arbitration. Well, that's a different topic. So that's the first thing that must exist, the rule of law. Secondly, there must be adequate institutional capacity to deliver access to justice. The institutional capacity does not depend on the courts alone, but on all the stakeholders who participate in the justice delivery system. That includes judges, the court personnel, the advocates themselves, and the litigants is in civil proceedings. In relation to criminal proceedings, then you have the prosecutor and the defendant. All the stakeholders contribute to the existence of the capacity to deliver. But of course, capacity also depends on funding, and that funding affects both the physical infrastructure, because sometimes you go to Nigerian courts and you wonder whether this is a court of law. I've been to courts outside Lagos where they have no windows, and you ask yourself, how can this, why are you addressing anyone here as my lord or my lady? There's nothing lovely in this environment. So if you want, you cannot command me or demand respect from me. You have to try and earn my respect. And the first thing I see is something which looks like a court of law, which has the aura of the court of law, so that when you enter into it, you feel that you are in the temple of justice. Not when you enter into it, you feel like it's not even as good as a pepper soup joint. You have to have that. But also, you have to have money to fund the day-to-day running of the courts. You have to recruit professional court staff. Those all go into your institutional capacity. So it's not just about the judges. Because anyone who has been to a Nigerian court, you see files piled up from the ceiling to the floor. And you're wondering, how can this be? How can they find your file? And it's not surprising that many of these files get lost. You simply cannot run such a chaotic system and expect it to deliver quality justice for you. We also need, in a federal system like Nigeria, in order to ensure quality access, we need clarity in the definition and allocation of jurisdiction between the federal courts and the state courts. We need that clarity. In my own experience, a lot of the appeals that go from the federal high court are concerned solely with the allocation of jurisdiction. Is this within the jurisdiction? The magic section 251. But I'll come back to that point. The fourth determinant, my view, is procedural fairness. You cannot get quality access to justice if the job or the administration of civil and criminal justice is unfair. Fifth determinant, the speed with which these disputes are resolved. That's where I started from. The problem here is not access, it's exit. But I've also had experience in Nigeria where justice was dispensed with speedily. Where a case that started in February in a trial with witnesses who came from abroad, finished typewritten judgment by December. 10 months. But I won't tell you why that happened. The sixth determinant, or the seventh, is a reliable and effective appeal system. Reliable and effective appeal system. So that where you are unhappy, you can appeal. But there must be filters to determine which cases merit going on appeal and which ones should still be. The judges are human beings, no one plays God. Sometimes you win, sometimes you lose. The fact that you've lost doesn't mean you must always appeal. You can accept that. It's unfortunate, but I have to accept this is what the judge thinks. And we have to have that as a mindset as well. But the situation where you can be in the appellate court for 10 years, even you
as the advocate, has forgotten all about the case. The ninth requirement is that there must be a robust regime for the award of costs. I really cannot see any improvement. I mean, disregarding everything I've said, I cannot see any improvement, at least in civil justice administration in Nigeria, without root and branch reform of the cost system. It's impossible. You must give people an incentive to litigate responsibly. The idea that someone can take me to court, put me to expenses for 12 years, and at the end of it you award me 100,000 naira is a joke. We'll have only one Supreme Court. To get to the Supreme Court, you have to fly to Abuja. And because the airlines are not reliable, you probably need to go overnight. And so you incur these expenses, which on any view, just the flight expense alone is more than 100,000 naira. And you can be the victorious party in the Supreme Court and they award you 100 or 200,000 naira today. And that money today is maybe like $500 or $600. So the idea that someone has litigated for 12 years and that the client has paid that person $500 or 100,000 naira can only exist in the mind of a person who lives in a strange land, not in this country. And so you ask yourself, given that the lack of reality as to the award of cost, what exactly do it cost them when they award cost? And finally, you must have an effective judgment enforcement regime. Because in this country, when you get your judgment, that is where your problem begins. You now know for the first time that enforcement of judgment is a separate type of litigation that can take another 10 years to complete. So having spent 10 or 12 years going from the High Court to the Court of Appeal to the Supreme Court, and you think that you are now at the final destination, someone says to you, your difficulties are just about to begin. And that process can go all the way back to the Supreme Court in the enforcement. I just don't see how that can be called justice, let alone quality justice, whatever quality means in this context. So for me, those are some of the determinants that must be present before one can aspire to having quality access to justice in Nigeria. But I want to say one or two things about some of the points that I have highlighted. Of course, in Nigeria, for the average person who has not been to court, the main contact with the administration of justice system is in criminal litigation. And that's why there's so much fascination with criminal litigation. And it's not just the ordinary people who are fascinated, it's also even the movie makers. The whole portrayal of law is about the criminal process. In Nigeria, whenever a person tells you that there is no confidence in the judiciary, what they are telling you likely is in the criminal justice system. And you see a lot of comments. For example, in the editorial of 30 November 2015 by Punch, it says that lawyers and judges contrive to delay corruption trials, hinder recovery of looted funds, and have lost public confidence are well known. What is urgently required today is the initiation of reforms to identify and punish corrupt judges while building institutional capacity to eliminate the stench from the template. These are very strong words. And those words are not completely correct. But there is the perception, which may be right or wrong, that the Nigerian system, no matter how many times you legislate, we lack the capacity to enforce our laws. And that's why I'm often amused when I hear people recommend federal legislation. Know that there are areas where we might need to legislate or correct our legislation. But the problem in Nigeria, the most central problem, is not the lack of an adequate legislative framework or legal framework. It is the incapacity to enforce even the existing laws. And we have to ask ourselves, why are we unable to enforce our laws? Why? I sat once as a sole arbitrator in an LCRA arbitration in London. The parties were Nigerians. I was surprised when I came for a party somewhere and someone called me aside to tell me that one of the parties was his friend and that I should do something for it. I was very taken aback because I thought I came for a party. And I know that the person who was putting me aside to get and tell me that one of the parties was his friend is one of the most vocal critics of corruption in the administration. So I was saying to what's it? Get to the point. What are you asking me to do? I should throw this award in favor of your client. So when I talk about the lack of capacity, it is about all of us, you and I. It's not about some mystery. The judges are human beings. You see some of them, they're people like us. And we are also his stakeholders. It is a known fact that Nigeria has had great difficulty in bringing to book wealthy people or politicians. You don't need any example. Examples are all there. You see the trial of the Senate president, and all there, no progress. And at least in that, we as lawyers, we should have the humility to accept that we are to blame. When I practice in England, nobody tells me how to delay because the timetable is a timetable. It's impossible for a judge to come for a day to see and then turn up and say, I'm looking for an adjournment. It is impossible. I have no experience in almost 30 years of it happening. It is just not. So why is that inevitable in this society? The worst are those who write letters. They don't even have the humility to turn up. They write a letter to the court and say, I'm sorry, I'm in a superior court somewhere, I cannot attend. I don't know since when that became a reason not to turn up. No one ever teaches any law student that if you have a case in the Supreme Court and you have one in the High Court, you shouldn't attend the High Court. But unfortunately, I understand that if the High Court judge were to strike it out because that person did not turn up, the Supreme Court will restore it and rebuke the High Court judge for doing what he's supposed to do. So how can you run such a system? I'll give you some examples because I often say that we have contracted out our criminal justice enforcement to foreign courts. I mean, James Ibori, good friend of mine, went to a San Pedro High Court and was acquitted without taking a plea. Said there was no case to answer. On the same evidence, before a British court, he pleaded guilty. There must be something wrong. The laws must be very different, either in their content or in their application. If one judge looks at this and says there is no case to answer, no prima facie case, however low you define that threshold, and then on the same evidence, the same person says, I'm guilty, I don't even need to worry about the trial. And on that evidence, he was convicted, his wife was convicted, his mistress was convicted, his sister was convicted. But in Nigeria, there was no case to answer. So we have to ask ourselves, what is the reason for that? Is it just based on the criminal statutes? Has steps changed between England and Nigeria? Why is it that those people were convicted and were not even allowed to take a plea in Nigeria? Is that the fault of the judges? or is it the fault of the lawyers? Or is it the fault of both the lawyers and the judges? In England, in contrast, everybody goes to jail if you steal. And there are some recent examples of members of parliament who have gone to jail. I'll give you three. Dennis McShane, the former Labour Europe minister, was sentenced to 6 months in December 2013 after admitting bogus expense claims amounting to £13,000. 13, just £13,000. Went to jail for 6 months. Then Jim Devine, the former Labour MP for Livingston, was jailed for 16 months in March 2011 for making false claims totaling £8,385. £8,385. Not even up to 2 million naira. A member of parliament going to jail for 16 months. The third example I will give you. February 2011, Eric Ilsley, ex-Labour MP for Barnsley Central, was jailed for 12 months for dishonestly pocketing more than 14,000 by exaggerating claims relating to the second road in London. So claiming to be incurring accommodation for sittings of the parliament in London, whereas it was in relation to the second road. £14,000. He went to jail for 12 months. The other man went to jail for 16 months for £8,385. And then the man who got the least punishment, 6 months, in December 2013, for stealing only £13,000. If you aggregate all these monies, they are not up to 5 million naira. 3 high-standing members of society went to jail. In Nigeria, no one has been brought to jail. Instead of Nigerians thinking about how to take people and put in prison, they are preoccupied with minor things. We want to give immunity to the principal officers. What about the governors who left office in 2003? How many of them have you convicted? Who have no immunity? What about those who left in 2007? How many have you convicted? Not one. What about those that left in 2011? How many have you convicted? What about those that left in 2015? How many have you convicted? So why are you preoccupied with the existence and scope of immunity? When those who have no immunity and you have access to them, they have not been able to track them. In trying to see how we can move our society forward, it seems to me that as lawyers, we must take responsibility for at least 70 to 80% of the problems. It is not the judges, it is the lawyers. And my sadness about it is that if you qualify as a lawyer in this system, if all you know is this dysfunctional system, you think that this is how law should be practiced. And that's a real tragedy. Because you are telling people this is not how to do it, but the only experience they have is this system. And so I say to someone who writes to me and says he won't turn up in court, or even more discourteously, I'm in court at 9, and he sends the junior to tell me that he should stand the case down for 2 hours to allow him to come and meet me 2 hours later. He did not call me yesterday. He did not even call me before 9. He sent his junior to inform me to sit in court waiting for him to turn up 2 hours later. And when I refuse, they say I'm unreasonable. If I have nothing else to do, why can't I be reading my law reports in my office instead of sitting down, chewing my nails and waiting for someone for 2 hours? So I think that we have to look at ourselves as lawyers and say, are we actually playing the role which will enable access to justice to exist? Or are we just pompous and taking ourselves too seriously? Because we're now growing up in a wholly dysfunctional court system which respects lawyers excessively. And so someone writes a letter and the judge adjourns. I think that the senior lawyers have a big responsibility. And anyone who is watching the trial of the second president cannot but think that we are a Mickey Mouse country. The issues are very straightforward. Submit yourself to hearing. If you are guilty, if you are innocent, you be acquitted and you go. If you are guilty and you don't accept it, you follow the appellate system. But the idea that you cannot be tried at all, and that there are some lawyers who are helping you to ensure that you are not tried, for me is tragic. And it's a disgrace to those lawyers who see themselves as being paid to carry out that exercise. And I feel sorry also for the courts, because the courts have to stand firm. And especially in matters of interlocutory rulings, the appellate courts must support the lower courts. Because if the appellate courts keep reversing the lower courts, then of course they are in the mindset of, I don't know what the people upstairs are going to say. If I do this, they reverse me. If I do that, they reverse me. So you don't know what to do. I just give in. The adjournment is a good example. But in saying all this, I'm not saying that the judges themselves have no role to play. The judges are human beings and they live in this Nigeria. But they've all also grown up, as my Lord Justice Ayola pointed out, going through the Nigerian system. So you go through a dysfunctional education system which ill-equips you to practice properly. You graduate from a dysfunctional education system into a dysfunctional legal profession, which ill-equips you to practice properly. And then as an inadequate legal practitioner, you lobby and you become a judge. You then become part of the dysfunctional judiciary. Or you lobby and become court registrar, and you find that they don't even understand registry functions at all. And so the system gets perpetuated at every level. And you're asking yourself, where is the escape? How do I escape this? Someone should extricate me from this. And there's nowhere to run to. But one of the things that I have found more disconcerting is the unwillingness of the judges, especially the trial judges, to give bench rulings. The unwillingness to give bench rulings. There is a trial, and I have to tell you, before I came to practice in Nigeria about 10 years ago, I thought trials were actually trials. Because when I started trial in England, the trial finishes during the window. And if there is an overrun, maybe 2 days, and then you finish. But I applied in the Lagos State High Court, and after about 30 minutes of cross-examination, they said this witness is finished, and I wanted them to bring the next witness. The judge said, no, we are finished, take a date. I said, but we have 3 days. He said, but I have other cases too. So I was surprised because I didn't know that if you reserve back-to-back days that you can't use them. And then we got 3 months. And I'll tell you, that trial eventually concluded 2 years from the dates that the first witness was called. It's impossible to regard that. Even I, as a lawyer, I couldn't remember the question that I asked 2 years ago or 9 months ago. So I'm wondering, how does this judge remember the countenance of a witness over a 2-year period? And why should you accord any greater probative value to what this judge evaluates than anyone else? Because it's guesswork. He cannot possibly remember whether this witness was doing something funny if the period is 2 years. I had a case once where someone raised a question, where someone asked a question in cross-examination, and I said, no, that's an improper question to ask in cross-examination, and we argued about it, and the judge said he was going to rule on it. I said, my God, what do you mean by that? He said she was going to adjourn, so we're going to adjourn this trial to rule on whether the question can be asked. Do you know we got a 3-month adjournment for that. And the day that the case came back, the judge was not there, so they said they had to fix information because they cannot fix something without his consent. So in order to resolve the question, whether this was a proper question, wrong question, it took us almost 9 months. So when the judges say they criticize them too much, of course, yes, we're too quick to condemn, the judges perform a very difficult role, but many of them give you cause to complain. If you cannot say, I stand by this, I may be right or wrong, that's my plea. The question is allowed or is not allowed. That's the essence of an effective, decisive justice system. You cannot reserve everything because you say you need to make NGC returns and they are counting the quota. But I cannot finish this without talking about, as a people, our own obsession with procedure. You know, when I articulated the determinants for good justice system, I said a fair procedure. And procedure is very important because there has to be a process that you have to start and follow. But Nigerian law, in my experience, is excessively and destructively procedural. Nigerian civil and criminal justice system is beholden to procedure at the expense of substance. Our civil and criminal justice systems, until lately at least in the case of criminal justice, are just obsessed with form rather than substance. I have never seen any system that is as procedural as this, and I do not see how any system as procedural as Nigerian law can deliver justice, because what you deliver is technical justice at the end of the day. And in saying that, I am not saying that there cannot be procedure. There must be a process that you have to follow, because in every country, whether it's the UK, the US, Canada, anywhere, Australia, there has to be a process for initiating proceedings and the steps that you must take. So every system has its own procedure, and we must have our procedure. But our own obsession and self-indulgence with our procedure is things that don't matter, little things. You haven't crossed your eye, you haven't crossed your teeth, you haven't dotted your eye, become real issues. And then they tell you, because you haven't done that, this process is incompetent. And because this process is incompetent, it runs the court of jurisdiction. And because it runs the court of jurisdiction, you cannot take any step. You will see a man fall, you cannot put something on it. My word, you are saying to yourself, someone should rescue you from this false logic. Very false logic. And then to make it worse, these issues can now be brought all the way to the Supreme Court, so long as you are able to formulate a question of law. So your appeal becomes a appeal of law on this question, whether you have dotted your I or crossed your T. And you burden the ultimate court in the land with that. And after 12 years, you come back to start again. And maybe at the time you come back, the limitation period would have expired. And the limitation period, so you now have two problems. You have your failure to go to your eye, and you now have even a bigger problem. You have limitation to contend with. And then they say to you, well, so you have to hire lawyers in Nigeria who understand how to negotiate these booby traps that are all over the field. You get them. And finally, I'd like to say that sometimes our courts are cynical. And my lady, I want to use the Supreme Court as an example. In civil appeals, the average civil appeal takes about 8 to 10 years at the current time to get heard. But under the rules of the Supreme Court, you are required to file your brief 90 days after the transmission of the record. So if you file your brief according to that timetable, by the time the appeal comes to be heard, it will be 10 years. You would have forgotten what cases you cited. and many new developments might have happened. And it's not your fault, but the case is just there torpedoed. But if you fail to file your brief because you estimate that it takes 10 years and you now want to wait until the second or third year to file your brief, the Supreme Court will strike out your appeal for want of diligent prosecution. Because you fail to file your brief within 90 days. In most cases, I think in practice, that power is not exercised, say for maybe 9 months or 12 months. But they will strike out your appeal for want of diligent prosecution. Because you did not file the brief within, say, 12 months or 9 months. But the ones that you file within the 90 days, they have not considered, and they will not consider for 10 years. The way you fail to file within 9 or 12 months is strike out, and in the case of the Supreme Court, because it is not even striking out, it's dismissal that the rule says. It is very serious. You cannot come back. And when you ask them, they say they are trying to manage their appeals. And you ask yourself, how does that give you access to justice? If your case is meritorious, and there's an important point worthy of consideration by the apex court, how can the fact that you did not file your brief within 1 year in respect of an appeal that will not be held for at least another 9 years mean that you are permanently shut out from the seat of justice? You don't need rocket science to see that there's something wrong with that. I come back to case management, and I had said it was a final thing. I know my time is up. Just one more. When the State introduced case management powers under the generalship of Oshibajo and the generalship of Mr. Tawari, we came from England to come and tell them how the English system works, the pre-trial reviews, and how you can move things from A to B. Those things are there. And then you can ask yourself, roughly they came into force around 2005. Now we have had at least 10 years of experience. And you ask yourself, taking stock, what has happened to that system? In my own limited experience, and my experience is extremely limited, it cannot be extrapolated at all. Very limited. But the system has not worked. The judges have refused and failed to exercise their case management powers. Notwithstanding the new rules, they are all operating in the old mindset. So I have a case which is faster, and 5 years old, it hasn't been finished. I have said they should deliver this slow track. Because if fast track takes 5 years, with only 2 witnesses, what will a slow track or a normal track take? Maybe 20 years. So the problem we have in this country is not legislation, it's not making of rules. It's your unwillingness to enforce whatever you have. No matter what you introduce in this country, it will not run because people have a mindset which is rooted in the past. It's the same thing that our chairman said. You want change, but when you see the change, you don't want to embrace it. You say you want to stand where you are. The legal profession is the most guilty party in that respect. I'd like to say that we must decide on how, when I outlined my points, I said I had cost and appeals. In relation to appeals, there must be some filter. It is impossible to just allow anyone who can formulate a question to go all the way to the Supreme Court. The counter argument I have heard about that is that the judges are calling the lower courts, and that if you erect filters or obstacles to free right of appeal, then there will be miscarriages of justice at every turn. I don't buy that at all. You cannot say because there is that problem, you now multiply the problem. The solution is to try and get it. Lower court judges to be more efficient. But there must be some filter. You cannot just make a formulate a question of law whether or not my grandmother's birth certificate is accurate and then I go to Supreme Court. That cannot. No system can function. Even if you have 100 judges in the Supreme Court, without a filter for appeals that should be heard, that court will continually be overburdened. So that amendment must be done. There is no question. We can solve other problems, the problem of a reliable court of appeal, but we cannot just allow people to exercise appeal rights. But the same is, of course, one has to remember that the same Supreme Court wanted governorship election appeals to come to them. So we have to be, Nigeria is a funny place. We're really sorry for them that they have overworked. And then they say, you know about people, you're enjoying. We went to see these governorship elections to hear. And you just say, what type of country is that? They're saying they're overworked and they're saying they want more work. So what is wrong with us asking? Now, in relation to cost, and Lagos State is also a good example because in 2005, I'm looking at you, yes, Solicitor General. In 2005, we said to them, every system, a system that has no effect is a useless system. A system that has no incentive is a useless system. If I can do what I like, when I like it, I go with no consequence. Why should I change? You must give me an incentive to behave properly. In the area of litigation, that incentive includes the case management powers that the court exercise, but more importantly, the jurisdiction to award costs. In Lagos State Civil Procedure Rules, we have beautiful rules for the assessment of costs. In fact, Lagos State Civil Procedure even has provisions for indemnity costs. So not just standard taxation, where you get 60 or 66%. Indemnity means indemnity. Show me proof of your cost and then you recover everything, provided it is reasonably incurred. When you go to the Lagos State High Court, and then at the end of your trial, you win your case, and you say, my lady, because there are many my ladies in Lagos State High Court, I want to go and make my submissions on cost. He said, no, I'm going to assess it now. I said, no, the rules provide for indemnity costs. I want to go and make submissions. Why in this case, you should exercise indemnity costs to show how this litigant has delayed the proceedings for 3 years and to show the cost that it has put my client to. And the judge says, no. At the end of the day, he give you 50,000 or 100,000 or 200,000. And say, by awarding costs, I don't want to use costs to prevent access to justice. So they tell you that they award derisory costs so as not to prevent people from coming to the court, which is not correct. In 2004, and this is Justice Ayola's lecture, my friend Dr. Gorewu carried out an investigation on the costs awarded in Nigerian courts in 1970s and 1980s. And that showed that in the 1970s and 1980s, the Nigerian courts were awarding costs in excess of 300,000 naira. At that time, 1 naira was $1. So that's the equivalent of awarding costs to be in excess of $300,000. There is no Nigerian court that can award that. But unless they go back, there is no solution. Because if we don't know where we're going, at least we should know where we're coming from. And to ask ourselves, where did we become disconnected with the reality? Ladies and gentlemen, as I said, it's giving me a great pleasure to speak to you. And I hope I have not bored you too much. I'd like to say, in reference to our judges, that the judges do a very difficult task, and we should not be too quick to criticize them. In that respect, I add my own comments to those of my lady, Justice Kekere Ekun, and because judges perform their functions in the public, the court of public justice, system of open justice, they are very vulnerable to criticism. If you lose, you say the judge is corrupt. Is that correct or incompetent? So we must have the spirit that you can lose. Everywhere people lose. We must, as a people, we don't give up. See the ease with which Mr. Cameron lost and left. And we're all watching on television. packing his bags, with the Prime Minister carrying his own bags and putting in the car. Where have we lost as a people? We are fighting for cause for our own good. Thank you. I was actually taking you through the standing ovation. Let's have a very Thank you so much. Thank you so much, sir. When you have a lecturer, a teacher of law, and a lawyer, have a captive audience, you don't expect anything less. The starting note on how ex-Prime Minister Cameron, in fact, is quite informative, has implication for the Nigerian public officer. I imagine if it had been the Nigerian public officer who was from Yoruba, imagine all manners of sentiments that would be thrown. There's still food to be eaten. Public officers don't disengage in Nigeria. They hold on to power. That's great, no matter what. But you see, what the inferences from that institution tells us that, Madam, judicial sector reform, there's the body, the big body before you. And all right, as we proceed, we want to move very fast. But you know, we have this problem of another infiltration in the Nigerian system. These Chinese schools. You know, it has become a sort of headache, especially when you get to hear all those funny sounds. So please, if your phone is made in America, or made in England, or perhaps in Germany, put it on silence. But if it is Chinese phone, please switch it off. Please. Remove the battery, because when you switch it off, and the call comes in, it will still sound. So please remove the battery. Thank you very much, so that we don't interrupt our speakers here. We still have some of them here. Let me invite the representative, the secretary to the Federal Government Anti-Corruption Committee, Professor Owasmo, represented here by Dr. Sani. Dr. Sani, please.
Thank you very much. May I seek the indulgence of the top table to stand on the existing protocol. So I give all the excellencies on this side that doing that. I also give my learned senior on the other side. I've seen a couple of my learned senior and my friends. Time will not permit me to go into individual acknowledgement. But I must say a few words of encouragement about the convener, who is my friend and my colleague. I wonder where you get your energy. And you seem to have this magic touch. So I'm happy that you are leading a crew that is dedicated to irreversible change of this nation. I've seen all the highlights of your core value, and there is no doubt, like the learned SCN said, we can only move forward by looking backward. Because Nigeria was not like this. The dream of those who put Nigeria together was not that Nigeria will emerge as a failed state. So if we try to rediscover some of the old values, there is no doubt, with everyone working in concert and subscribing to certain core values, we will begin to gain some traction. So ladies and gentlemen, as you have heard, I'm a representative of Professor Bolaji Owasmo. Professor Wasoye is somebody I like to be like when I grow up. A man who became a professor at less than 40. A man with boundless energy as well. Is committed to social change and social work in different sectors. And I will simply say that it's a shared privilege for me to represent him at this honors gathering. So I appreciate you for inviting me, and I hope I will not do any disservice to his excellent paper. Prof has a 32-page paper, I wish I could go through everything line by line so that I can do justice to it, but time will not permit me to do this. So I will build on the foundation that had already been laid by the erudite professor and the learned Seal and QC, who had carefully identified all the factors, all the indicators that has made the judicial system weak. So the topic I will be speaking to is dangers of a weak judicial system. So I will not want to bore you by repeating some of the factors that have been heavily established. So I will proceed by giving an highlight of the 32-page paper and then speak to the introduction, pick some aspects of the paper, and then read the conclusion. I hope this is acceptable. So ladies and gentlemen, the paper is divided into 8 parts. Part 1 is the introduction. Part 2 speaks on role of the judiciary. Part 3 is independence of the judiciary. Part 4, competence of judges. Part 5, corruption in judiciary. Part 6, delay in the administration of justice in Nigeria. Part 7, which I consider the meat of the paper, implications of the weak judiciary. Then part 8, conclusion. And in conclusion, I will also add the key words of my own. So, I read the introduction. There is perhaps no hesitation, no institution more saddled with lofty expectation than the judiciary. First, there is the expectation to be impartial and incorruptible. Next, there is the expectation to dispense justice without delay, despite infrastructural and budgetary impediments. Seemingly paradoxical to this is the expectation to maintain a high jurisprudential standard in well-thought-out judgments and not to miscarry justice. Last but not the least is the expectation to be independent of the sister arms of government, the executive and the legislature, while checking their excesses with recourse to the same constitution that served the triplets. The Nigerian judiciary is, of course, not immune from these expectations. This is more so because the depravity of the society, the prevalent culture and impunity, and disregard for the rule of law. The recent anti-corruption crusade by the federal government, among other factors, make this expectation higher for the Nigerian judiciary. However, as utopian as these expectations might seem to a cynic, the importance of living up to them cannot be overemphasized. Not only is the integrity of the judiciary dependent on meeting this expectation, the stability of the nation's nascent democracy and preservation of civil order also rests on their fulfillment. Admittedly, it is not an easy feat to theorize about the judiciary or the task of ensuring a strong and effective judiciary may be achieved. This is because of the complex nature of the machinery that makes judiciary function as an institution. It is therefore imperative as a substratum of any discourse on judiciary to delineate what judiciary
years. And Prof adopted a narrow definition of judiciary which departed from that of the Black's Law Dictionary. And he said, for this purpose, a reference to the judiciary is a reference to judges, and where the context so admits, administrative personnel are employed by the courts. So the focal point is the judges. So the paper seeks to examine the structure and the role of the Nigerian judiciary, extant frameworks for the appointment and the discipline of the members of the bench, and factors militating against the fulfillment of the earlier identified lofty expectation of the society from the judiciary. The aim is to underscore the danger of a weak judiciary and prescribe measures strengthening the Nigerian system. If you want to imagine what a weak judicial system is, just imagine a weak building. God forbid that this building where we are all seated is weak. Nobody wants to stand under a weak structure, and we are all witnesses to the menace of the danger of weak building and collapse of building in Lagos. So that is exactly what Prof is speaking to. In part 2, he identified all the courts established pursuant to section 66B of the Constitution, and although the Constitution does not provide an exhaustive list of the functions of the judiciary, the functions may be conveniently summarized as follows. 1. Interpretation of law and the Constitution. 2. Check non-powers of the other branches of government. 3. Timely resolution and remedy of civil grievances. Then 4. Punishment of proven infraction of these functions. So in part B, Prof had gone to elaborate on each of these, which I will not bother to detain you. Then on page 7, in order for the judiciary to effectively discharge its role in the society, it is important that it remains 1. Independent, 2. Competent and jurisprudentially sound, 3. Uncompromised and free from corruption. The strength and effectiveness of the Nigerian judiciary will now be examined in the light of this criteria. So Prof has now gone to town to speak to each of these 3 issues, and sincerely his verdict is almost identical that of the candidates. So he looked at the appointment of judicial officers in Nigeria. I will only pick the aspect of the paper where he has said something that is quite different from. So he said the executive on the appointment, he said the executive, president or governor, and the legislature, the Senate and the House of Assembly of a state are involved in the process of appointing or confirming respectively the heads of courts. In addition, the executive is involved in the process of appointing other judicial officers who have been recommended by the NJC. However, in each case, an appointment cannot be made or confirmed without the recommendation of the National Judicial Council. This much was held by the Court of Appeal recently in the case involving the appointment of the Chief Judge of Rivers State. This curtails any tendency that the executive and the legislature might otherwise have to unpick and install judges who will do their bidding. It is also clear that the NJC is neither bound to give any reason for recommending or refusing to recommend a candidate for the position of a judicial officer or head of court, nor is it bound by the advice of the Judicial Service Commission in recommending a candidate. It is therefore clear that the main authority responsible for the appointment of judicial officer is the NJC. It would appear that the roles played by the executive and the legislature in the process are reasonable and innocuous compromises. It is also justified in a democracy that the executive and the legislature maintain such roles since they comprise of persons directly elected by citizens of Nigeria. Their participation in the process is therefore the only form of contribution of the electorate to the process of appointing judicial officers. This is far more tolerable and harmless compromise when compared with what obtains in some countries where judges are elected by popular votes. Then he considered the procedure for appointment of judicial officer. Have not read this in any book, have not seen it in any literature. He identified 8 stages. The first one is notice to the governor to the governor or to the CJ of Nigeria, the CJN. All these are contained in the NJC guidelines and procedural rules for the appointment of judicial officers. So the first one is notice to the governor or to the CJN. The second one is the Chief Justice consent. Third, call for nomination or expression of interest. Fourth, circulation of short list. Fifth, approval of provisional lists. Sixth, completion and return of NJC from A. Seven, consideration of memoranda and recommendation to the NJC. Then 8, the NJC's interview, deliberation and recommendation. Then God identified inadequacies in the procedure that he had outlined and discussed, and he made some far-reaching recommendations. The first one is on financial intelligence scrutiny. He said, look, it's not sufficient for judges to fill the code of conduct form and declare their asset after. And he likened this to locking the gates when the house has voted. He said that some intelligence should be gathered about concerning them by relevant security agencies, so that if such investigation come up with anything that can put us on inquiry, then the applicant can be called to respond. The circulation of the judicial list. He said we should widen the space. We should involve more people. It's not sufficient for the chairman of the MBA or the chairman of the MBA president alone to express an opinion about the quality of an applicant. Inviting objection from members of the public or through invitation of objection in national days will leave no room for admission to the bench of persons of impeachable character. This I find very, very radical. Risk of abuse of such policy such public consultation may be caused by strict requirements to substantiate otherwise frivolous allegations of impropriety. Then, absence of timetable, absence of time limit for the president of the governor to appoint. And he cited the recent example in Rivers State, and he said it should be time bound. Otherwise, it can be subject to abuse. The possible disparity in the period allowed for receipt of application and nomination. And finally, ambiguity in the wordings of the guideline. On discipline and removal of judicial officers in Nigeria, Prof. spoke extensively and concluded that the Constitution does not make express mention of the role of the NJC in removing the heads of courts, as it only expressly provides that they may be removed by the President acting on the address supported by 2/3 majority of the Senate, or as the case may be, a governor acting on the address supported by two-thirds majority of the House of Assembly of the state. Notwithstanding this omission, the Supreme Court has remedied these potential threats to judicial independence by holding that heads of court cannot be removed without the input of the agency. In the case of Elelu, Appeal, and AG Federation, the Supreme Court held that although there is no provision for the NJC to play any role in the removal of a chief judge of a state, such a role must be implied from 1. The fact that the NJC plays a vital role in the appointment of and in exercising disciplinary control over the CJ. And 2. The conditions for the removal specified under section 29291A2 of the Constitution cannot be satisfied without the input of the NJC, which is equipped with the personnel and resources to investigate whether the conditions are fulfilled. He spoke on tenure of judicial officers in Nigeria, financial autonomy and remuneration and condition of service. And he had a very strong word concerning, let me read this in full because there is a current issue on this, which I believe members of the public will be better enlightened because I was really enlightened. The judiciary cannot be truly independent if it has no financial autonomy and independence in determining the condition of service of its officers. The 1999 Constitution guarantees the financial autonomy of the judiciary by providing that the amount standing to the credit of the judiciary in the Consolidated Revenue Fund of the Federation shall be paid to the NJC for disbursements to the heads of court established for the Federation and the state. In order for the Nigerian judiciary to be truly independent as an institution, there needs be full implementation of the functional guarantees of financial autonomy. So there is no doubt or no debate about that whatsoever. The salaries, allowances, pensions, gratuity, and other retirement benefits of judicial officers are also guaranteed by the 1999 Constitution. In addition to providing that salaries and allowances shall be charged upon the Consolidated Revenue Fund of the Federation, the Commission also provides that the remuneration and salaries paid to judicial officers as well as their condition of service shall not be altered to their disadvantage after their appointment. This guarantees individual independence of the judges and enables them to discharge their duties without fear of financial repression by the executive. In practice, the judiciary do not enjoy a first-line charge to the extent required by the Constitution. The problem is, first, with inadequate allocation, and secondly, with the delay in release of funds. It was on account of the full release of allocation in advance that the Judicial Staff Union of Nigeria, JUSON, embarked on strike. Because the argument is, this money has been allocated to us. Give it to us. Don't let us come cap in hand begging at all times, which is the meaning. Sound argument. But let's see God's view on this. Okay, financial autonomy may appear, although the Johnson's demand for compliance with the constitutional requirements of financial autonomy may appear justifiable, given the shabby manner the judiciary is made to beg for release of funds. The reality is that the annual budgetary allocation cannot be delivered to the judiciary in advance because the money is not available in the account waiting to be paid out. Remember, under section 162, we spend everything as we receive them. So annual budgets are prospective statements of income and expenditure of government. Thus, if the government does not raise sufficient revenue as anticipated, all arms of government may experience shortfall in their allocation for the year. Given this reality, the request by GISON for advanced disbursement of the judiciary's shares of budgetary allocation cannot stand. Spoke about competence of judges. Then I quickly go to corruption in the judiciary. He highlighted administrative corruption, operational corruptions, and factors responsible for corruption in the judiciary. He highlighted inadequate remuneration, lack of financial scrutiny prior to appointment, lack of transparency in the process of appointment, indolence of some judges, congestions of the dockets, and political manipulation of the processes of appointment and removal of judges. Then he spoke about delay in administration. I don't want anyone to climax to what the landlords have done in this regard. So I quickly go to part 7 of the paper. The lawyers. He also spoke about lawyers, about the prosecutor, prison, police, and custodian authority, apportioning them. This quickly takes me to implication of a weak judiciary. An objective evaluation of the health of the Nigerian judiciary in the light of the issues considered above will inevitably tilt the scale towards weakness than strength. So if it is just mere weakness, I think we are doing weakly compared to the nation where we use the law such as failed state and there is some argumentative words. So the way forward is to look backward and then try to discover where rain started beating us. The implication for the rule of law. The rule of law connotes 4 universal principles. The judiciary is the means of holding people accountable under the law. Where the judiciary is weak, the rule of law crumbles because there will be no viable means of holding the government or the people accountable under the law. Similarly, a weak judiciary will be unable promptly and qualitatively deliver justice. The common man will be left with no option other than recourse to self-help, resulting in anarchy and a frustration of the social contract upon civilized society operates. The implication for good governance, implication for economic development, commerce, investment, competition, thrive better where there is the will of God. The risk of doing business increases where obligors can breach their contracted obligations without timely remedies for breach of contract. This also increases the incentive for contracting parties to disregard contractual commitments. Similarly, investors will also be reluctant to commit resources to endeavors where the law regulating business are uncertain, or where counterparties may steer the wheel of a case law in another direction by paying the right price in bribes to judges. Also, foreign investors will be discouraged to invest in a country where the executive or the legislature may unilaterally change the economic rules of engagement without any prospect of being held accountable when the jurisdiction of the funds are revoked. Bob also spoke about the implication for human rights and also the implication for legal profession and jurisprudence. Permit me to note that the judiciary is the crown of the legal profession. If the judiciary is weak, its weakness resonates down to the bar and the entire legal system. The judiciary, crippled by corruption, delays in administration, incompetence, dependence on other arms of government, and other weaknesses will negatively impact on the quality and growth of a nation's legal profession. It will also stunt the development of the law. thereby impeding the potency of the law in keeping up with the growing trends and development in various aspects of life in the society. In conclusion, the health of the judiciary determines the health of other arms of government, the well-being of the people, and the development of the nation. Accordingly, a weak judiciary portends negatively for the country. The Nigerian judiciary has come a long way since 1963, when it became truly independent from the Privy Council in England. The judiciary has survived turbulent phases, during which it was in shackles of military governments and had no independence from dictatorial authorities, which constituted the executive arm of government. However, it can be seen from the above discourse that the problems currently bedeviling the Nigerian judiciary are of different nature. They relate majorly to the challenges of ensuring the integrity and the diligence of members of the bench, and minimizing delays in the administration of justice. There is also the challenge of securing increased funding in order to overhaul the infrastructural and technological inadequacies currently clogging the wheel of justice. In the light of these challenges, an objective evaluation of the current state of the Nigerian judiciary cannot result in a clean bill of health. It is no wonder that Nigeria suffers from the earlier discussed implications of a weak judiciary, such as failure of the rule of law, poor governance, slow economic development, disregard for human rights, among other symptoms. The infirmities of the judiciary are, however, curable. I'm happy is ending on the note of optimism. We must never become cynical about the progress and the development of this nation. So while the infirmities of the judiciary are, however, curable where there is a political will, I think as Amy identified another theme, maybe for your future roundtable or for your future lecture. Because what is this monster called political will? So I'm of course, we can begin to give it content after proper engagement and agreement on irreducible minimum that anyone that is occupying any office must discharge as a fulfillment of his mandate to the social contract period. So while it remains sacrosanct that the judiciary be independent from the executive and the legislative arm of government, the support of these are vital to the actualizations of reforms required to strengthen the judiciary. Ladies and gentlemen, these are the solutions
Thank you so much. Remember in this tradition of the academic, I think that presentation still is awesome. We are moving very fast now. Now we've got the time when we need to give perspective and dimensions to all these presentations. And of course, the very distinguished mind that Mohan Kodas is very much ready. Let me quickly announce that I know a number of people are agitated for questions, perhaps their own thoughts to the issue here. If you have such, this our hostesses will be going around. Write your name, the question you wish to ask. If it's a complaint, let's also know. And if it's just a mere observation, let's also know. And add over the nearest. Also, don't forget to put your name, it's important. And put over to the nearest hostess to you. Now on this note, let me quickly invite to the podium the warrior Worry. Mr. Fola Otawari. Atawari. It's part of the Nigerian
Thank you very much. Thank you. Just to let you know, my original family name was Atawari. Then my grandfather, who was in tin mining in Jos, was convinced by his English manager to change it to Afro-Warren. I have been told many times to reverse it, but I think I prefer it as it is. Thank you.
My Lord, Chairman, my lady, distinguished high table, distinguished ladies and gentlemen. I've been given a very huge task because there was supposed to be 3 discussants if you look at your program. But now I'm supposed to bear the burden of 3. So you bear with me if I move from side to side as I try to capture some of the issues. Now, I don't think anybody can deceive themselves anymore, that Nigerian institutions are in dire straits. Let us not pretend, because like in America, that has been turning a blind eye to the reality of racism since the 1960s. These recent shootings have brought the discussion to the fore. And for the first time in America's history, people are being honest about race. They are just honest, because the only way you can change the system is to confront. And that's why I'm not of the school that any institution in Nigeria that's not performing to optimum should be protected or given undue. I think we should confront. The problem is that I've had personal experience of it. In spite of my status, just to recover my premises, I'm retired now. That's where my income comes from. To recover my premises in the magistrate's court between 2012 and 2016 was hell on earth. As a systemic failure, we must confront it. And I'll get to what I think the main reasons are. It was only when my caretaker suggested that we shut off the water and the electricity that the tenant voluntarily left. So I had to don't use self-help. I use self-help. I needed the money. This is how millions of people's assets are tied up in the judicial system. Capital flows, emotional, a man is arrested, and when I was director of public prosecutions, 80% of arrests were not justified. 80%. And if we delayed, breadwinners of families were waiting in prison indefinitely. So you cut off the family's income, you frustrate the wife emotionally, and then people will condemn her if she looks for comfort elsewhere or support. So the system has emotional costs, it has psychological costs, and it has financial costs. So we must be very careful that we do not just gather here again today and move on as if everything is okay. The thing about political will is that the system now is that once the courts can resolve election disputes and put people in power, after that the politicians have no more interest. They only wait for the next time they need the court to resolve their gubernatorial, presidential, legislature. After that, and the courts take up so much of the time and energy of the court to resolve this dispute, and then we go back to normal, where you and I cannot recover our premises, cannot recover bank loans. Legitimate cases, in cursory reading of most proceedings in Nigeria will show who the beneficiary ought to be, even for a non-lawyer. So why is it so difficult that we cannot resolve that? So that I just wanted to get that off my plate, because I've been involved in this process for a very long time, and I think
we must up the conversation, we must make it more forceful, but we must also make it very clear what the issues are. So I said, I gave the paper some time ago, but I want to, first of all, acknowledge the fact that the speakers today, in my view, have raised all the issues that are important to, as the title of the paper says, access to justice, dangers of a compromised or incompetent judiciary. I'm not so sure about the title, but let's look at, let's call it exit from justice with benefits as a key issue before us. Now, taking those speakers' points, they narrowed it down to rule of law, the lack of decisiveness of the system, the lack of adequate institutional capacity, that includes both courts and stakeholders, funding, clarity of jurisdiction between state and federal high courts, and we all know that that was okay. There was no problem up to when Abacha's regime introduced a new type of federal high court. The federal high court used to be essentially a revenue court for federal revenue, especially customs. But in our wisdom, because we are very wise, we decided to give it more powers. And now we have complete confusion, where if I'm sued in one court, I can run to another to stop that process. Then we have a lack of procedural fairness. Problems with speed of resolution of judicial process, reliable and effective appeal system, the lack of filters that prevent unmerited cases from entering the system, and I'll address that to some degree later. And I assume, sir, that I haven't standing here for 3 people, I have all their time. Thank you very much. So that there is clarity of the case before, so that I don't come back and ask for extension of time and all of that thing. So then we have a problem with enforcing judgments. Sometimes you want to enforce a judgment, you need to get the police or bailiff, and when you get to the place to enforce, the man has his own mopo there. That's the Nigeria we have created. Anybody can get police, put them, and then it becomes a contest between the court judgment, their own police, and the mopo. And mopo is loyalty to the person who has been feeding it for the past 3 months that has been on duty. So we have many issues to deal with in Nigeria. We need to get serious. Change doesn't just mean change of government. It's change of the way we do things. Our mindset. Now, then we have, challenges in enforcing the law, issues of appointment of judges, financial independence of the judiciary, etc. All of them well set out and well articulated. So my job is just to sort of respond and expand these key issues, which we've been talking about forever, but which we probably now, with the Vice President, who is a reformer, with the Attorney General, with the Chief Justice of the Home, may begin to look at the possibility of reforming them. But if we can't reform anything if we are not going to change our mindset. That's the most important thing. And if we have destroyed our secondary schools, destroyed our universities, destroyed our institutions, it's going to be very difficult to engineer the kind of mindset we need. Because the demands of modernity are very high. We decided in our wisdom to leave our communal village life and move into the modern world. The question is whether our minds and attitudes have moved with us. That is the challenge for Nigeria. We have all the institutions of a modern state, but whether they function to the optimum is a question. So let me start by saying that, as has been said, a reasonable length of trial is an important characteristic of good judicial performance. We all know that. Independence, fairness of adjudication, predictability of court decisions, etc. And lengthy trials undermine the system. Now, for me, and I say this with all due respect to all speakers, all opinions, etc., the greatest challenge of our courts and court system. It's not the amount of money they have or don't have, but the governance systems of the court. The governance systems. It cannot be said that the inability of a judge to give a bench ruling is because the judiciary doesn't get enough money. No. It cannot be said that a 5-year delay because of procedure and appeals and interlocutory appeals and a judge not sitting when they are supposed to is as a result of lack of fund. So let's get the mindset first before we now look at how to fund the newly thinking system. Because if you throw money at a bad system, it is just going to be wasted. Now, today the high courts are run almost like bureaucracies, right? And to most people, they are typically seen as old and monstrous machines with a lot of red tape, much inefficiency, and in need of much repair. Some observers argue that bureaucratic organizations are more interested in compliance with formal procedures than the achievement of concrete results. So there's a need for change in terms of what your purpose is. If you are just a file pusher and you are not saying how many people benefited at the outcome of that process, then you're just a bureaucracy not serving anybody's interest. Now, forms of accountability are linked more with keeping track of relevant procedural events through the use of registers and paper forms. These are the typical systems used to certify that the procedure prescribed within the norm has been respected. But these tools do not consider elements such as efficiency or quality of the service, nor can they effectively measure outcomes. And we don't measure outcomes in Nigeria. We don't measure. That is why we celebrate the appointment of a minister rather than his exit and assessment of whether he did well. We congratulate even before we get to the office because we are not interested in the result. Honorable Minister, this, my Lord. At the end of the day, it disappears into history. And then we come here again and discuss the same problems that he was supposed to resolve. So, now, I'm not trying to my Lord's ladies and gentlemen, has been described variously as a radical or realistic, idealistic, but I'm not a theorist. As my lady said, I have run systems, and when I run them seriously, with limited resources and so on. It doesn't mean I'm an angel. When I leave work, I play. But let us get to our office and be useful and be purposeful. Now, this is what an observer said of today's court administrations across Nigeria. He said, most of today's judiciary administrations, which are clones of state and federal civil services, are run very much like those of their parent bureaucracies. Slow, cumbersome, disorganized, poor at record keeping, untidy, inefficient, hierarchical, poor at facility maintenance and asset management, conformist, poorly staffed, leading to administrative complacency with very little resemblance to the desired efficiency. And the judges are oftentimes victims of this state of affairs. So we are saying that if a judge is appointed to a high court, he is not really going to get involved in the governance issues of the whole system. He'll just assume there's a system in place, I'm sitting as a judge, they come to court, my lord, everybody sits, then they call a case, then they say, where is the file? Where is the process? Oh, it hasn't been brought yet. It hasn't come up yet. Where is it? Has it disappeared? It's somewhere down in the heart body of the court, but somehow it hasn't come up to the judge's file so he can deal with it immediately. So that judge, apart from the parties, is a victim of poor governance. There's no excuse for a paper filed on Friday not to be in the court's file by Monday. What's the mystery about it? Are you carrying a ton of bricks? No. In this age of technology, everybody here, phones were ringing all over the place. But when it comes to use technology for hard work, we don't do it. But we are very good at disturbing the kids with our phones. So again, I say, let's get serious. It's a mindset problem. Whether it's a judiciary, how you run a general hospital, you tell everybody our hospital starts work at 7. You rush there, you hurry up there, hurry. Maybe you are taking your daughter, oh yeah, we have to get there. You get there, of course the gate is not open. Then you wait. A system that should have been able to manage 2 people, you turn back, there are already 100 people behind you. Then at 8 o'clock, the man just stumbles there. And so, why you people waiting? Doesn't even look at you, he opens the gate. So, a waiting space that should have been for 50 people, there are now 300 people. Problem. Then you're waiting, the doctor doesn't come till 11. Nothing is holding up this system except attitude. We are too mean to each other. And I always said when I served in office, one day I'll be out there and I'll be coming back to this city to ask for something. So we must all see it as a collective enterprise and not some vague whatever. So, now, there have been many reforms in the judiciary and other parts of the system in Nigeria. Many. The judicial service has withstood many years and periods of reform, though, without essentially changing in nature and character. And indeed, its history is one of long periods of routine, the normal, interrupted from time to time with occasional frenzied reform. But its administrative and governance systems and procedures have changed little. And these reforms have sometimes seemed no more than attempts at damage control. Not improvement, but damage control. So you have the perception the place is inefficient, but if we go into reform mode, people will back up and give us some space. But at the end of the process, nothing has changed. And I don't speak as an individual. I speak with verdict. Even the judges have admitted. But sometimes we are in denial. It's always somebody else's fault. It's not my fault. If we had more money, we would do better. But if your governance systems are faulty, all the money in the world won't change anything. We talk of political will. I don't know what that expression means, political will. We don't need political will to, sorry, please can you develop some political will? We have all manner of excuses for our failure. All manner of excuses. We used to say that the problem with Nigeria was education. 50 years ago, at independence, so the more people we educate, the better we become. We now have 10,000% more graduates than we had then. So what's happened? Merely going to school to read geography or law is not going to resolve the problem. It is the philosophy you adopt in applying this talent that will make a difference. Nigeria runs an economic system. Now, we've been talking about, so let's look at solutions and some of the issues, because I guess I'm almost running out of time. But if nobody says so, I'll just go. I've said that the problem with the judiciary is due to a flawed governance system that doesn't enable or even compel judicial officers to perform to their optimum. We have not paid enough attention to administrative process. Indeed, all the country's institutions need urgent process review. So I urge, first of all, that there has to be a root and branch process review as to what happens between when a man files his paper and how soon it gets to court. What is the procedure? What happens to the file? Is it by electronic process or by paper process? If there are desks, because in Nigeria and like in any other civil servant, you have offices, you have positions. Executive Officer 1, Executive Officer 2, Senior Executive Officer 1, Senior Executive Officer 2, Chief Executive Officer 1, 2 and 3, and so on. Many of them, I assure you, are not even clear what their function is. I assure you, I've been in the system. So process review means let us examine the process by which files and processes move through the court system. Let us understand, maybe there are 11 desks. So that same process will stop at 11 places. So you ask them, why do you have 11 stops? They will say, that's the way we've been doing it. So I say that for improved governance of the court administration, not the judges, the administration, because you can be frustrated out of the court by a single clerical or registrar. They will not bury your file. They will not bury it. And when they see you say, what about my file? I have 5 minutes. To vote. All right, let me try and hurry up. Let me leave the example. We all know the example. You see, when you run a country where contact with an institution criminalizes you, then you know you have a problem. You are a law-abiding citizen to go and get a service from a government institution, and that institution will criminalize you by compelling you to pay a bribe. That's a problem. That's a serious problem. Now, we're going to all the costs and so on. So, issues for me when it comes to this, so I say process review first of all. So we cut down the time it takes for processes to move within the system. Better record keeping. The record keeping is appalling. Files are piling up, some of them are mildewed. You know, we should start converting that to digital by now. Then, and I did it when I was the Commissioner of Lands. We moved all our COOs, some of them as far back as 1857, onto e-platform. So it can be done. And I think that's your extra money. Now, within the judiciary, within the judicial officers themselves, there are some problems which I started in the courts in 1981. So I've been around for quite some time. I'm a pre-independence baby. So I've seen. Nowadays, judicial staff can just be transferred on a whim. Just go. Where is it now? It's gone to Badagry High Court. What is the procedure by which you get your cases to be carried on? Is there a policy written anywhere? So we must fine-tune that process. An internal transfer, for whatever reasons of the chief judge, should not have a negative impact on the parties. If you are moving me to Badagry from Lagos, and you are moving my case to Badagry, what about my transport costs and all these things? We don't consider these things. We just say we are doing transfer. So we must look at all these issues. Then you may get to court and they say the judge has gone on retreat somewhere, abroad, Singapore, whatever. Meanwhile, when you were taking the dates, you were given no notice that there will be a retreat. And I think that's an unfortunate choice of word, retreat, because it means moving back from reality. It is not fair. And that's probably why we haven't done it much. So it is not fair to the parties. It is not fair to. So we must be more conscious of the impact of certain administrative decisions that we take. Then, as I said, mindset. Now, to end, and Dr. QC mentioned the lack of filters. That means I can just throw anything into the system and it will go up, and then we'll be complaining of congestion. Now, the courts of appeal are supposed to act as filters to the Supreme Court. So only the most serious cases of national implication are supposed to get to the Supreme Court. The Court of Appeal is supposed to have settled that matter, but that is not the case today. Driven by all manner of factors, we are never satisfied. We are poor losers, so we want to go on forever. I'm sure if they open another front window, people will go there and all of that. Then, and it is also driven by the search for a particular number of appeals so that you can apply for sanction. So that also adds to the, because I can just, especially in criminal law, you see cases that should never go to the Supreme Court, but they're there. So we must decide what type of system we want to run. If appeals are important to qualification for SAN, let them be meritorious appeals, not just any type of appeal. It's not about number, it's about intellectual capacity. I'm nearly finished before I'm accused of breaching my own admonition. Now, there was a very serious question raised about the inability of the state to prosecute certain people. That means that accused persons and their lawyers can frustrate due prosecution of a case, can push back against the people's will. And I say that the Supreme Court, more than any other court, is responsible for this state of affairs. There was nothing wrong with the criminal justice system. I was DPP, nobody ever raised objection to my charges or my information until the Supreme Court, in that case of a state versus Abata, let a man go, acquitted a man on the basis of proof of evidence, not on the basis of a trial. They looked at the proof of evidence and said there's no case against this man. And then they also said, and you cannot even try him again. Once the highest court in the land endorsed the fact that you could object to the process, not to the trial, then the window just flew open. So I would urge that the Supreme Court review that decision and restore the clear foundations of criminal prosecution. Criminal prosecution is not a prosecution by government. That's why they call it public prosecution. It is a prosecution on behalf of all of us. And that
was a very angry warrior. Alright, a very angry warrior. So let's have it again, please, for well, time check, we are about 36 minutes after 2. That's less than 40 minutes of which we are trying to anchor properly and exit this program by 3 p.m. latest. Unfortunately, the discussant here had done a lot in inciting people to ask questions. Before he had the mic, I had just about three questions. Now I have 15. So you can just imagine my predicament now. And we cannot take more than 5. What justice to be done to the issue. So I will use my discussion. I will still have 1 or 2 other comments coming in, distinguished comments coming from the floor. So we want to move as fast as possible. If you have your questions here and are not answered or not announced, I am sorry. I am very sure you got the inspiration to ask after a while. Mr. Baweria was perhaps my talk is another one again. Alright, this is from Mr. A. Adiwali, who is a member of the UEC. Professor Odita has already highlighted the use of cost to determine wasting in civil cases. Based on his experience in the UK, what are his restrictions to prevent time wasting? Okay, sorry, I will just be clear. We have the strongest news from Lord Justice Kiri, aka Quality Justice, who wants to take who has to be confirmed to take a flight. We need to excuse her, but she wants to also make 1 or 2 reactions before she leaves us.
Thank you very much. And the chairman and other distinguished members of the head team. I just wanted to make 1 or 2 very brief comments. I would say on the whole, my take from everything that has been said is that we all need a new mindset. We need to be ready to embrace this change we're talking about, to have the system that we want. I want to say that the present Chief Justice of Nigeria is very open to reform, and in his own way he has embraced a lot of ideas that have been brought forward. We are also in the process of trying to make our system more 21st century by introducing information technology. We are still in the process, but at least it's something that we know is necessary. A lot of the suggestions that have been made will be taken on board, and many very useful suggestions have been made, which I will convey to the Honorable Chief Justice of Nigeria, so that we can look at some areas where reform can be expedited. I think one of the very valuable suggestions made by the professor was about costs. The efficacy of costs that have been awarded. It's not only to deter people from coming to court, but to make sure that you really have genuine grievances, you really have genuine reasons for coming to court. Another issue that was raised has to do with having a filter system. This is something we have agitated the system, but I would say that where the solution is not bringing everything to the Supreme Court. Definitely, if there's an amendment to the court, for instance, which permits the Supreme Court to hear appeals only with leave, so the Supreme Court would give leave for those appeals that should be heard. Definitely, it will reduce the number of appeals that come. Because as I was expressing with the chairman and some of the members of the high table here, the Supreme Court now is basically repeating precedents that have been firmly settled. So what is the point of that? So if you have a case that has been decided by the High Court, that has been affirmed by the Court of Appeal, that should be the end of the matter. If you have any issue against individual justices of that court, follow the correct procedure so that those who are incompetent or who are not doing their job will be weeded out. I feel that when you say we know those who are corrupt, but what is happening to it? What is happening to them? If you know those who are corrupt and you are not corrupt yourself, or you are not involved in the corruption you are alleging against them, then take the necessary steps so that they can be weeded out of the system and the message can be sent. There was also this issue specifically about dismissal of an appeal. If you fail to file your brief, I just want to clarify that the procedure in the court is that if there's a failure to file a brief within the period stipulated by the rules, the adverse party is permitted to bring an application to court. That application must be served on the other party. If the court is satisfied that the other party has received notice that this appeal he has filed, he has failed to comply with the rules, and his appeal is about to be dismissed, and does not respond, then the court has no option than to dismiss it. And also, what we say is that when such applications are filed, they are taken as, in some cases, just trying to wake up the other side. Because what we are saying now is that some matters are filed in court for other reasons, and therefore there is no anxiety to see that they are concluded. So, but if you do get such an application, and perhaps because it has taken such a long time for the matter to get to the hearing stage, you've lost track of it. When you receive such an application, it wakes you up. And when you come to court, if you file an application seeking to take the steps that you fail to take, that application will be heard and granted. And we usually will give preference to that as opposed to the one that seeks to dismiss the appeal. The final point I want to comment on again is the review of the decision of the Supreme Court in the Abacha case. There is a procedure if you want the court to review any of its decisions. So I think that again, we are legal practitioners, senior advocates of Nigeria, some of the cases which they feel there was actually a miscarriage of justice or a wrong application of the law, is to take the necessary step also to file the necessary papers to have the court look at that decision. And the court will constitute a panel and look at it, and because curiae could be invited to see if there is any reason to set aside that decision. So that's how the system works. But all in all, I will say that we all agree that there is need for change, there is need for improvement in the system, and we are open to the suggestions that are generated by forums such as this. And once again, I will commend the convener for putting this together, for the very insightful contributions from all those who have spoken today. Thank you very much.
All right, I guess we excuse Lord Justice Lekere. We have about 25 minutes for this session, so we'll rush through this. We still have one or two more comments coming. The first question was directed at Professor Ogita. This is from Akiola Agbo. I think this is the second question. Where do we hang this balance in the judgments delivered by the Supreme Court in an election matter in the state in Nigeria? Election conducted on the same day under the same atmosphere. At least 20 cross state legislators were sacked for election malpractices and upholding the election of the governor. That's, I hope any of panelists can handle that. And this is also for Professor Ogita. In view of the fact that there are too many conflicting judgments by different divisions of the Court of Appeal, will it be right for cases relating to governorship election at the Court of Appeal and at the Court of Appeal? Will it not be questioned here? So we don't have another lecture. On the 15th, DPP Lagos signed their report. Certain individuals from the pressure conspired to commit felony based on police suspect confessional statement. Up to date, DPP Lagos is yet to assign the case to any judge. The complaint letter dated 35/16 has not been responded to. Please, if there is a rep here, if there is a representative here, I'm willing to wait because the young man is languishing in the victory. But I'm not too sure there is a rep here. Ezekiel, I own this magazine. Our leaders spend on quality time, energies and monies on issues that do not benefit the citizen anyway, but issues that will move us forward are often not attended to. What shall we do to make our leaders be productive with the yearnings and aspirations of the citizen, such as rule of law, good governance, press freedom, I think that one is so. This is from Dr. Adedayo. How might we secure and protect the lives of judges even when the executive and the legislators are highly guided by state security apparatus? I think because the one that I hope members of the panel are listening to that. Then Olajide Dotun Omoboriwo, if government authority find it so difficult to compel the concerned agencies to obey court order, case study of electricity tariff increase by the Ministry of Power, Works and Housing. How far do you think we can go in restructuring the legal system of our country? That's from Oladipo. I am Mrs. Rahim. How do common man get justice when a rich man or influential man can use the court to get funny orders? For instance, the High Court judge giving order that a medical doctor should move his hospital away from the rich man's hospital. And when the doctor appealed and got judgment against the unconstitutional order of the High Court judge, the rich man resorted to using the police to charge the doctor for embezzlement of funds. And the DPP also played the script of the rich man just because the rich man wanted the doctor to move his hospital away. How do common man get justice? I think former solicitor general will handle that. This is from Mr. Debo, Executive Chairman, Commission Against Corrupt Leaders. Question: is it not possible for the lawyers and judges that help a criminal known to them escape justice be prosecuted as accomplices of the criminal? I'll come again. Is it not possible for the lawyers and judges that helped a criminal known to them escape justice be prosecuted as accomplices of the criminal? This is because most criminals confess their sins to their lawyers and lawyers also confide in corrupt judges. I think we'll stop there.
As far as I recall, there are three issues that you'd like me to address. I think the first one is on the costs. I'm not sure I remember the precise question now. The second one is on the governor's elections. What happened at the Supreme Court where they dismissed several appeals on one day? And the appeals to Supreme Court from governorship elections. There is no doubt that the election litigation places the court under severe stress, both in terms of the resources which are devoted, and also in terms of the pressures which the courts feel to do what they see as appropriate. I think the latter pressure is part of the wider symptom of the judges being unable to resist pressure from influential people. Why is it that appeals from governorship elections cannot stop at the court of appeal? What was wrong when those appeals stopped at the Supreme Court? And why did the Supreme Court ask for more appeals to come? I don't know what the answers are. Maybe some of you do. In relation to those election petitions that came, election appeals that came from Rivers State, Abia State, all of them were dismissed on one day. I understand that those cases were dismissed on the basis that what do we call them? Those machines they use at elections could not override clear provisions of the Constitution. If you don't agree with that decision, it is for you as a citizen of Nigeria to discuss it publicly or subject it to Lawyer General review and explain why you think those decisions are wrong. But it's not for us, because we have not agreed with a particular decision, to think that necessarily someone has taken money or has been used improperly. I don't have evidence. There are many judicial decisions that I disagree with, both here in England, in America, but it doesn't follow that because I do not agree, I therefore think they are wrong. They may be right. I'm more worried about costs issue, because I think that still is a key determinant of access and efficiency in our justice administration system. Now, by cost, of course, I'm not talking just about the monies we pay to the lawyers. That's not good. You have costs. If you come to court, you have to file your case, you have filing fee. That's a cost to you. If your case needs an expert to come and give evidence, you have to get the expert and pay the expert. That's additional cost. If you're a witness and you do not reside where the court is, someone has to pay for your cost to come to the venue of the court. You might even stay overnight in a hotel. Those costs are all part of the cost of litigation. In addition, of course, to the costs that you pay to your own lawyer. I do not see how this system can function properly unless all those costs are recoverable from someone. They must be recoverable from someone. There are many ways you can look at it. You can say, well, do we amend our rules? Some of the rules, like the Lagos State High Court rules, contain provisions which allow the judges to award costs. But when a case has taken a long time, you really cannot assess the cost summarily. I believe that if the courts take into account the need not to impede people from coming to court, but also to give them the right incentive to litigate properly, the balance that the questioner has can be restored.
Hello. The session is still on. I know that item 7 is being served. Usually when item 7 is served, we have your please carry. Please, can we stop that? Can we stop the service? Let's suspend it. We have just about 15 minutes. Let's suspend. Hello. Please, let's suspend the service for now. Let us suspend it. We just have 10 minutes and let's conclude this. We have 2 very important items here. We have a question from. You want to come here?
Thank you very much. I know that. Yeah, no more. I know that people are in a hurry to like our lunch. But I want to address 3 questions. One of them is, how does a poor man get justice? Sorry? How does the poor man? Well, in Lagos State, what I would advise is that anybody who has a matter of justice and he feels that his rights are being denied him because he is poor should go to the office of the public defender. They are all over the place. Office of, and it's a functioning office. Go there. There's no mistake about it. All over the world, legal aid helps the poor. They have 12 offices across the state. Go and find out. Use your phone properly. Go to Google. You will see the addresses there. Office of the public defender. Now, another question was about a delay in handling a criminal case, and then the complaint was that the DPP was delaying placing the case before a judge. It is not the DPP's duty to do that. It is the duty of the registry. So to find out about that case, you need to go to the High Court registry. Now, the final question I'd like to address is from Comrade Adeoye. Kule, is it? I don't know. Of the Bus Conductors Association of Nigeria, Lagos State Chapter. Bus Conductors Association. He says that their members are molested while on duty in terms of fees collection by sister existing union, and the illegal arrest and attitude towards our members by law enforcement agencies and related forces. I will only say to the comrade, when conductors treat citizens with respect, then agencies will treat you with respect. That's how it works. Thank you very much. I've been given an extension of time, even though I didn't appeal. I understand what I believe this is from some very, very enterprising people from the association of them. And honestly, I've watched this gentleman doing sign language all afternoon. And I'm very impressed at their desire to inform themselves about it. Because sometimes in Nigeria, people with full eyes, full ears, don't know what's going on. Now, the question is, I understand all what is being said here. Now, I like that. Now, my question is, as a deep person, as a disabled person, you need easy access to courtrooms and interpreters. I agree. As far as I know, hasn't been provided or employed in the court. That's a sign language expert. That's very true. So we have a lot of issues in Nigeria. Small issues that, are very important. Whenever we have an issue at the court and even at the police station, we always have to employ our own interpreter, which isn't right. I agree. When people with other language, English, Yoruba, Hausa, or Igbo, go to court, they have better access than we the deaf. Very profound. And indicates what I said, that we are not addressing the real issues in Nigeria. The advice I will give to the association is that they should go to the agency that Lagos State set up to help the disabled. There is an agency, I can't remember the name, it was established in 2014, because I always say, the institutional route is the best route. So I would advise that you find out, go on Google, enter Lagos State law for the disabled, and it will give you information about where to go, because it is that agency that can best fight your cause. I hope that satisfies your question. Thank you very much.
Yes, a very good one. We still have 6 minutes, working within time. We want to quickly acknowledge Mr. Mohammed Ogbanago. Yes, Mr. Mohammed Ogbanago, please. Mr. Mohammed Ogbanago. Mr. Mohammed Ogbanago. Please give Mrs. Ogbanago a round of applause as he walks to the podium. This is a very special Nigerian. This is a man that actually recovered the sum of $10,000 as a security man with the United Bank for Africa, and he returned it from a customer of the bank, and he returned it. It's a number of us. They have also conferred the award of Epitome of Honesty, of Mr. Ogbanago. And this is how we want Nigerians that are honest, that are excellent, that are hardworking to be acknowledged in public events like this. I respectfully invite the chairman of this occasion, Honorable Justice Emmanuel Ayola, to give us exclusive remarks. A lot of applause, please. I know some of our hands are busy. And no noise. You don't talk while you are eating.
Distinguished audience, we have come very close to the end of a very successful event. First, let me congratulate Dr. Badre for generating this idea. wish it is something we can do at least once in a month, if not twice in a month. Let me personally acknowledge my appreciation to the lecturer, Professor Peter, for his very inspiring lecture. Mr. Anthony Warren for his enlightening contribution. Finally, let me thank the representative of the Attorney General for her contribution. Finally, let me add my own contribution because I have not spoken as much as I should. We love change. We for change for the better in our nation. We are very sentimental as a people when we hear about change. Most of the time when we listen to inspiring talks about change, we are almost every time reminded about how bad we are and we want to move on from being so bad. But let me tell you the strategy. Anybody who lives in Nigeria in the olden days, and I can count myself as one of those who live in the olden days, we know that we need those olden days to repair the present day. Because in those olden days there was integrity. You did not need to preach to people before you had stability. In those olden days there was discipline. You do not vote against a teacher if he disciplines you. In the judicial system, if the court determines that you should file your papers within 14 days, you will not hesitate to file your papers within 14 days. Discipline in a nation reflects in every sector of a labor, be it in judiciary, be it in administration, be it in anything. Where we are today, because we as a people have lost that discipline. And when we lose discipline, there is no lessons. So I would suggest to you is united action for change. What can make meaningful change is to make the present and the future from the past. Do not let us look at the past and the future and just sentimental and emotional about it. The future is the future. And I can assure anybody who listens that if we look at the past, it is because we are very detached from the past. That is why we are where today. People born 60 years ago will not know the past we are talking about. There is no history of the past. There is no history of integrity of the past. There is no history of education of the past. We as individuals who live in the past can tell you stories about how we became who we are today. I know that my father trained 3 of us at Oxford without borrowing money, without stealing money, without corruption. It was possible then, it is still possible today. There is so much discipline, so much integrity, and so much desire to fulfill the promises of our own lives. And that is where we should start the strategy for change. If you rely only on government to provide change, government cannot do it from the starting point. But government cannot change you. The pastor did not change you. The father, the imam cannot change you. Change must come from the individual. That change is a change I must change myself. 170 million Nigerians, if they don't want actualization of self-change, I can tell you, Nigeria will not move where we are today. So the strategy is to begin from the individual. Let me be an agent of change. Let me be an agent of self-change. Then we will have the type of country I'm looking forward to. That is my message to you, AC. And I thank you, AC, for bringing this occasion to me. I'll be part of the change. I'll be part of the strategy. And I have the authority he will be part of that change. He's already the commander-in-chief of change.
Thank you so much, sir. May I quickly announce that those questions that were not answered will be answered and posted on our website. And those who have their numbers on the questions will also have responses direct on their phones. Vote of thanks, Barrister Adepola Adewale Ade.
Thank you very much. Maybe on behalf of the UEC, the United Action for Change, vote of thanks. Indeed, very grateful for every person that made this event a success. For our item, we had a very rich faculty, Professor Udita, Bill Zayola, retired Justice of the Supreme Court, my Lord, who has now been tagged in quality justice, Justice Pikiri and Mr. Akowori. And let me just end by saying that, taking a cue from Mr. Akowori, Nigeria is not just a potentially reformable state. Nigeria is a potentially great state, and we'll get there by God's grace. Thank you very much.
Okay, distinguished representatives, you've all been very, very wonderful and very, very attentive audience, very, very delightful audience. Please, can you please, for God's sake, give yourself a good big round of applause for staying through this session for more than 4 hours. We will now close this session officially by singing our national anthem.
In